Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges are watching the Recovery Addict live stream in their court. The fireworks are not done.
I'm getting commentary on the case.
I'd agree that everything you just said is one of the most horrible things I've ever heard.
Alrighty, I think I'm ready. Oh my goodness, good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. We are all standing for some reason. We are all standing. Hang on. Why? Quit that, start it again. We tried turning it off and on again. Can you see it now? Can you hear it? Can you hear it?
I wake up, I hear it. I walk down the steps, I hear it. Open the back door to let the dog out, you hear it.
All right, it's working now. It's working. I think it's supposed to. Any second now, all the seats will just magically unfold, and everyone may take a seat. Someone stole the chairs. It's just slow. I think we have a Sarah Boone hearing today. I put it in the title today. I have to double check. I've got my oatmeal ready. Let's see. Yes, seats are starting to unfold. Where is that clip from? Which one? The hear it one or this one?
I'd agree that everything you just said is one of the most horrible things I've ever heard.
The everything you just said is one of the most horrible things you ever heard is from Tommy. And it's a part in the trial when the defense attorney is questioning his friend who had his wife that did all sorts of bad things behind his back. And he's describing in detail all the things his wife did. And he's like, isn't that horrible that she would do that? And he says, I agree that everything you just said is one of the most horrible things I've ever heard. It was like a gotcha moment. It was good. Sarah Boone is right now? Is that what you said? Right now? Right now? Where's Sarah Boone now? Wait. Oh, Sarah. Let's see. Just 1 second. Good morning. Welcome. Is that a clip? I need to use that. You want the Tommy one? I can make that available for you if you want it. I've got the very short version. It doesn't have the description of everything she does other than something about rolled over, but I can make it available. Yes, the Tommy one. Okay. When I let you share, when I share my Canva with you, are you able to download? Why is this so loud in my ears? Check 1 2, test 1 2. I stayed up late last night. I stayed up late last night because Blackmagic Design, the favorite company in the world that doesn't sponsor me, that makes most of my gear that I use, released an update for my switcher, which I've been waiting for anxiously, and they released an update for the software, which I've been waiting for anxiously, but it's not quite there. It's not quite there. I've got the software. I bought the pro version now, so I can play full screen video clips on replay. But the update for the software doesn't include that feature. It's like, hey, we've turned on a bunch of other features for you to test, but that one's not turned on, even though you already own that feature. So that's where we are. Good morning. Let's see. First of all, we have to do a couple things. Let's turn chat on. That's starters. Greeners. Today is an amazing day. Do you know why? Because Greeners has done something that I don't think has been done either ever before or in so long that I've forgotten the last time it happened. And that is he has won 4 consecutive mornings in a row being first in chat. Some people would say he was cheating. No, I didn't. Me? No, I didn't say that. I would say some people might, but they're wrong. I would put him more in the glutton for punishment category. Greeners, congratulations. You're first in chat once again. Mel Poison, I said it. He has inside knowledge. He's just quick. He's just really quick. Congratulations. He's going for the world record. Greeners, being first in chat has its punishments. And that punishment, and that punishment is internet ownership, which means that you're responsible for everything internet related worldwide. Which I'm going to lean on you sort of heavily because the feature that they just turned on my switcher. Here, let me turn this off the chat for just a second. Let me turn the feature they just turned on with the new update is through this little cable right here. There's a little 1 terabyte drive down on the bottom. I can record all 8 video sources simultaneously to that drive and share it over the network and work my replay off those while also using that same network connection to live stream. So I'm not sure if it really works very well. This will be the first test. I just hit this button and see up on the screen right there. It says ISO stop. When that goes red like this, now we're recording all 8 channels simultaneously. And as soon as I go over to this computer and bring all the 8 feeds into my replay, then I'm also playing them out simultaneously. So I'm going to tax the internet today. So I need you to be on your best game. Wow, that sounds a little weird. Anyway, we're going to turn that off for now. I don't need it right this very moment. All right, we have. Oh my goodness. We have birthdays today. We've got Mickey, Megan, Samantha, Minnie, 11 years old. Dog. Hey, Minnie. Good girl. Are all celebrating their special day with us today. Let's see. Sinbad 333 and hubby are celebrating their 44th wedding anniversary today. But we are going to sing Happy Birthday first, if I can find the song, which I had. There it is. It's back. In this patch, when I did the reset, it reset like all my presets. All my levels and adjustments are now completely out of whack. And so I sound like I'm yelling at myself in my ears. But the levels going out on the meters show that I'm actually a little bit quiet. Like I should be right here. It sounds like but man, it's hot. The mic is hot. All right. Selena says Minnie's my dog. That is too hot. I cannot. Let me crank that thing down. I could hear myself think with that so loud. I'm going to pull this. Is that a little better? That's much noise. Is Ari whispering, Judy, don't do that to me. I can see the levels. I know how many decibels are going out. All right, we're going to turn that down just a little bit and say that'll work. But now all the music's going to be loud. Well, we'll do it anyway. All right, we're going to sing Happy Birthday. And by we, I mean all of us. You are quiet. My voice is cranked up. My volume's cranked up. Are you guys being serious? Is it too quiet? We're going to sing Happy Birthday. First of all, I want you to be able to hear me sing. Not that I sing exceptionally well, but I am singing for you. So let's get the birthdays back on the screen here. Just 1 second. Here they are. And with that, I need to switch that here. So many things to do. So many things. All right, join with me singing. First of all, blend your voices with mine. We need to warm up first of all. La 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 la. There we go. Here we go. Stand up, shoulders back, deep breath. Project your voice to the back of the room. Blend your voice with those of your neighbors. Dancers at the ready. We're going to sing to Mickey, Megan, Samantha, and Minnie. Happy birthday to you. Happy birthday to you. Happy birthday, Mickey, Megan, Samantha, and Minnie. Happy birthday to you. Mickey, Megan, Samantha, and Minnie, it is your special day. Today, all the other days are great, but today is your special day. And I realize there are a million places you could be, a million people you could be with, but you've chosen to be here with us, so let us celebrate with you. Thank you. The privilege and pleasure is all ours. Hopefully, the greatest day of the whole year is yours. So if there's anything we do to make your day just a little bit better, please let us know. Thank you so much. Help yourself to the free pancakes at Denny's before they too go out of business, as everyone seems to do as soon as I mention them on the air. So I'll never get a sponsor at this rate. Oh, have a happy birthday. And it's a Friday as well. You get the whole weekend to celebrate. That is just wonderful. You guys, I really do hope you have a great birthday. And it looks like Mickey comes in and says, I came for the song today, RA, working on 73 trips around the sun like a good hobbit, gifting friends on my birthday. Mickey, thank you. Thank you, like a good hobbit. That is a great example to follow. We have a couple other notables that we need to mention here. Lynn in South Carolina, member for 9 months. Hello, Lynn. Says, I've missed y'all watching KR with Brandy. Love it here. Love RA, Mrs. RA, mods, and chat family. Thank you very much, Lynn. Christy G is here, member for 8 months. I'm so thankful to be part of such an amazing group. I love it here. Thank you, Christy. It wouldn't be the same without you here. Natalie O, member for 7 months. Happy Friday, y'all. I think you missed the Y on this. The Y is, there should be a Y like right there. I should say E. Oh, would help if I do this, huh? Let me go back. Lynn in South Carolina, member for 9 months. Congratulations. Thank you very much. I missed Mickey's as well. That wasn't on the screen either. It was a huge super chat. Came for the song 73. Congratulations. Thank you very much. Let's see. Christy, we said, thankful to be so part of such an amazing group. Love it here. That was for 8 months. Natalie O, 7 months. Happy Friday, all. Thank you very much. Tori, the Seed Lady, is here. Member for 11 months. Whoa. 11 whole months. Thank you for all you do. And I was saying on Natalie, right here, there should be a Y because you spelled y'all wrong. You spelled y'all wrong. Happy Friday, y'all. Dale's here for, whoa, look at this, 12 months. You turned orange today. Dale, congratulations. Time flies when you're hanging with your true crime family. Thanks, RA. Love y'all. Abby J, member for 6 months, says, I'm in the yellow now. Woohoo! Abby, congratulations. You look great. Yellow looks good on you. Pampered Glamper, member for 16 months. Says, I'm here. Indy Cindy 01, member for 12 months. Also in the orange. Love these anniversaries. I'm happy. It's Friday, and I'm so happy to be here with you. Well, this mic, it sounds like I need to stand back from it. It's never been this hot before. I'll fix it. I don't want you to hear all my terrible mouth noises. Like if my lips do a little when I'm talking or something. Right now it picks up everything, even that I can't normally hear. Indy Cindy, thank you very much. Happy Friday to you as well. Selena K gifted 5 memberships to kick off the morning. Thank you, Selena. Sherry Smith, member for 13 months, says another amazing month with group. I do. An awesome group, I think is what you meant. Thanks, Red Pen, for making it happen. Red Pen, thank you. Red Pen, I have to tell you, I had a terrible, terrible dream last night, and you were in it. It was terrible, but I don't want to, it's Friday. It was a nightmare. I didn't remember it till right now. It was literally a nightmare. I woke up nearly in tears. I might have to talk to my therapist. Golden Girl, member for 16 months. Happy Friday. Thank you. The dream was that you went away, Red Pen, and I was searching the chat. I was looking, and it was terrible because everyone else knew that you had gone away, and I didn't. I found out last, and so I was going back. I'm like, where's the message? Was it something I said? Was it something I did? I was gutted. I'm like, who will correct my English now? Who will mock my pronunciation? Who will double check my spelling? Yeah. It was terrible, Greener. Not Greeners, but Red Pen. Greeners is here. Let's see. Kayla Newell, member for 9 months, says, I'm a full-term addict. Full term, here we go. Gender reveal today only. Weather Watch, member for 17 months. Best chat on the webs. Weather Watch, great podcast last night. Thank you. Roy as well was with us. If you missed that, go back and watch it. It was a lot of fun. Once again, we neglected nearly completely to follow the schedule, and that was my fault. He did so much work preparing it, and then I just went a different direction, and he just rolled with it. It was cool. Ohio Jin, member for 17 months. Happy Friday. This is the best channel. Lego My Briefs says, I missed you. What, if anything, have you been up to? How's long do you have to listen? Lego Briefs. We've been having some fun here as well. Welcome. It is a wonderful day. It is Friday. I cannot find Sarah Boone's hearing. I'm lurking, and I don't know where it went. Sarah Boone. 8:45. Is she like an hour in? Are they? I might need some help. Britta Aller, member for 13 months, says, I feel like an OG. I can't believe it's another fantastic month with friends. What a wonderful place to watch true crime. Maddie, good to have you here. Brandy's awesome. We love her. She's amazing. She's done such a good job on KR as well. It's been a great trial to watch there. John, free Sarah Boone. Free Sarah Boone with the hashtag. I've never seen a rabbit shoot a bow before. Where's that picture from? It looks like a Watership Down meets AI contraption. Looks good. Joyful, member for 7 months. Hey. Hello. Welcome. All right. We are going to do what today is. Let me tell you why. Today is kicked back and it's Friday. And it's No Pants Friday, by the way. It's just a fun day because KR is not in court today. So we don't have KR. Our trial in Tennessee ended in a hung verdict. You heard me right. A hung verdict. Meaning they were hung and there was a verdict. I've never seen that before in my life. I still need somebody smarter than myself to explain what we witnessed there. We have a couple things coming up in KR. We have in the next week or so, we have some hearings coming up. We might even get some rulings on the change of venue, which we're waiting anxiously for, so we can all book our Airbnbs for March next year. We have an expected document sometime in the next roughly 3 to 4 weeks out of Arizona in the Kelly trial to see if the judge is going to dismiss that case with prejudice or not. Let's see, what else are we waiting for? Always Corey Richens, things happening there. She's got new lawyers. Carler, member for 10 months, says, thanks for the membership last night. You're welcome. I don't know who gave it to you. It might have been me, but you're welcome. I'll say that for everybody. Let's see. So we're probably going to do some court hopping today. If we get the Sarah Boone hearing, if that happens, or if it becomes available, or if you see where it is, please let me know, because I'm having trouble locating it. I know they said 8:45. A lot of the hearings for Sarah Boone, what they'll say is they'll book her for the morning, 8:45, 9 a.m., something like that. And then 11:30, they'll call the case. And she'll be in like the holding tank. It's like a live well for fishing, but it's for inmates. She'll be in the holding tank just waiting, and then they'll bring him in and handle it. Judge Simpson back online. I don't think he ever went offline. He just deleted a lot of his content. But I think he's still around. He's just possibly deleting his content after it's up, so you have to catch it live. We can do that though. See, Pro Se Florida Keys retrial. That's going to be the Treehouse murder trial. It's the one you're talking about, Dale. And I don't have the date. It's really close. It should be here in June. I was thinking 16th for some reason. Maybe that's a KR date. But yeah. Why is my mic so hot? Let me just do a quick. This is going to bug me forever. Okay, mic 1. Why is it split out? Hang on. Mic 1. Let's turn. Whoa, is that better? I was getting like a stereo effect instead of. Oh, that sounds so much better. That sounds good. This is where it should be, right here. Okay, I had it split for some reason for left-right instead of a mono.
Subject matter jurisdiction.
It was messing with my head, is what it was doing. All right, let's see. Cottontail Fox Squirrel, hello from Cape Town, South Africa. Welcome. Good to have you here. Say hello to Cape Town for us. Let's see. When the judge in Swift gave jurors instructions, he said to follow the changes and charges in order on the sheet, and he would be asking them where they get stuck if they do. Okay, Beth, it would have helped had I listened to those instructions, right? We skipped the instructions. I rarely do that, but because of our schedule and our timing, that's what we did. Sorry, I'm watching mod chat. Our mods are amazing. I'll say that now. I'll say that always. They're absolutely incredible. Yes. News this week, Selena. I believe yesterday or the day before, 2 more murders, named murders, not unknowns, but named murders that Lisk was charged with. So the list for Lisk grows. Let's see. They aren't going to retry the Swift case at this rate. Coach Karen, I think they will. I think they will. Just if you heard the venom in the voice of the Attorney General when he was asked about the reinstatement of bond, he's got either he has a vendetta or it's very personal for him. I think it's actually personal for him because he's in a election year and wants to retain his seat, and he needs to look like he's tough on crime to do that. That's my personal take. I know Pickles not politics, but that you can't tell me that there wasn't some other factor involved bringing a case that's 13 years old finally to trial during an election year with no new evidence over the last dozen years. Nothing retested, nothing. Oh, we finally got the results back. We reworked the DNA. We've got a new video footage. We got new witnesses come forward. Zero, nothing. There's got to be like some political undertones to that. And I think as long as those undertones are there, this case will be pushed forward. I think if it ends in another mistrial after the election, it would be dropped. All right. Let's see. Let's see. What else do we have? I'm trying to read all your chats here, and I'm a little lost. We'll be covering Wade Wilson. We've been talking with the court and some of the media with access, trying to gain access to that. I believe that starts on Monday. I'm not sure if we can call it the face tattoo trial because he may, depending on the judge's ruling, he may be allowed to cover his tattoos with makeup. So he might have an hour of makeup every morning to get ready for trial. Just don't touch your face. If it rubs off, then, it's terrible. But that looks like it starts on Monday for that one. I'm trying to find Sarah Boone. I cannot find it. I believe she's slated for a hearing today. Where did we have her? Sarah Boone. Check on here. It might be a little easier. If not, we're going to be doing some court hopping, possibly some parole hearings. We have, can always jump in on Young Thug, the perpetual trial. It's only got like 3 more years on that one. What's up with Chisholm? Donald. Okay, hang on.
The zombie apocalypse may be upon us.
There's a lawsuit.
Yeah, lawsuits all over the place. They happen.
This is not Burger King. People do not get to have it their way.
I saw a judge just briefly that I hadn't seen before.
Bring the jury.
Let me back up here just for a minute. I haven't seen her before. Where does she start?
I'm not a cat.
Let's see who this is. It's over Zoom. I can tell you that much. She's filling in for Donald Chisholm. So I don't know who she is. Probably the same circuit. You have to turn your mic on, Judge. We can't hear you. Hang on. Is that the kid?
Will the person on the Zoom identified as Zoom user tell me your name, please?
Is that the kid that...
Dominic Keithley.
Oh, that's...
Dominic.
You know who I thought he was?
Keithley. Okay, we could call your case right now. Let's see. Sergeant, are you able to, if I call the case now, are you available? You're muted.
Yes, ma'am.
Okay. Good morning, everybody. I'm going to call this case SP 435-9463. This is the state of Michigan versus Dominic Robert Keithley. Your appearance, please. We start with the sergeant and then the defendant driver. Okay.
Good morning, Sergeant Dauber, Stein State Police.
Good morning, sir. Thank you for coming. Your name, defendant driver?
Dominic Keithley.
Okay. This is the date and time set for the informal hearing on your traffic citation for a mobile device. Mr. Keithley, you have three options this morning. You can admit responsibility, where then it's turned over to me to assess fines and costs. You can admit responsibility with explanation, or you can deny responsibility. If you admit responsibility with explanation, you're admitting that you did what the traffic ticket says you did, but you're offering an explanation for the benefit of the sergeant. The sergeant is cloaked with authority on behalf of the people of the state of Michigan to, he has discretion, and only he has discretion on this, to amend your ticket to something less, either lesser money, lesser points, whatever. Right? But you have to know he's not obligated to, and I cannot force him to. But if people come on this informal hearing and want some consideration, or they're looking for grace or, you know, a break, then that is the selection, admit responsibility with explanation. If you admit responsibility or admit responsibility with explanation, you have no right of an appeal. Okay. You can file a motion, and to set aside your party admission, the motion may or may not be granted. You will have to post a bond. The third option is you deny responsibility. That's what you're saying to the sergeant and to me, to the court, that you didn't do what the ticket says you do. At that time, I go into a full informal hearing. I swear in the parties. I take testimony. That's an all or nothing hearing. You're either going to leave that hearing with the ticket as written, or you leave not responsible. If either, at the end of that hearing, if either side doesn't like my decision, you can appeal it. By proceeding today with an informal hearing, you give up your right to be represented by attorney. You give up your right to have this heard by a trial judge. I'm only a magistrate, and you give up your right to a jury. Having said all that, what's your choice?
I'll admit to it.
Okay, with explanation?
Yes, ma'am.
You want to tell the sergeant what was going on, what you've learned, the mitigating circumstances, take into consideration how you conducted yourself at the stop, okay?
Mm-hmm.
And be respectful, please. Go ahead.
Yes, ma'am. Well, I was just running late for work. I recently just joined the Carpenters Union, and I stay downriver, Wyandotte, Michigan. And I've been driving out to Ann Arbor for the past month for work. And I just was looking down at my phone for my GPS. And
I know there's a new law. You can't look down on your phone. You can't hold your phone. It's got to be, Sergeant, right? It has to be like in a holder. Can't be on your leg, right? Can't be in your hand. The old law, everybody said it was like GPS and that they weren't checking Facebook or Instagram or texting. But now we can't even do that, right, Sergeant?
Correct.
It's just got to be like Okay, sir,
Yes, ma'am.
Mr. Keedley, you gotta sit still, not walk, stop. And you need
Sorry.
to focus on me because you asked for this hearing and we're giving you the hearing. So you're not gonna do the hearing in something else, okay?
Yes, ma'am.
You've asked for this hearing, we're happy to give it to you, but you gotta sit still and it has to be important to you. Okay,
Okay, I will.
I think he's
All
at
right,
work.
thank you.
Yes, ma'am.
Sergeant, having heard that, is there anything you would like the court to consider?
I mean, he was polite on the stop, ma'am. Pretty much that's what he said. He admitted which must be on the day. As far as the speeding goes,
Wait 1 second. I did not call the case properly. I'm sorry. I just looked. I have 2 cases. So let me for the record clarify. He's got SP 4359463 and SP 4359463A. I am only on the mobile device ticket. You get to make a choice as to both of them. So what would you like to do, sir, on the speeding ticket? Boy, yeah, that's a big number. What do you want to do on that one? Do you want to admit responsibility with explanation, or deny?
I'll admit it, responsibility.
With explanation? Okay, so
Yes,
he was
ma'am.
going fast and he was checking his GPS. Sergeant, is there anything you would like to consider with these 2 cases in total?
as far as the speed goes, I'd be okay with amending that to 1 to 5 freeway.
Thank you.
Then as far as the device, I mean, that's a 0-point violation anyway. I believe that's just a fine. So
okay, so let's take this speeding one first, the A case. All right, sir, you've got to pay attention. Okay.
Yes, ma'am.
He's made a motion. He's giving you consideration from this like multi-point ticket to limited access 1 to 5 over. That's 0 points and I believe $130 fine.
Okay.
Any objection if I grant the motion?
No, ma'am.
Okay, do you admit that you are responsible for going 1 to 5 over?
Yes, ma'am.
Okay.
I want to know what the big number was. How fast was he really
that's
going?
130. Okay, so that's $130. How long do you need to pay?
I could pay it today when I get off work.
Okay, so I'm going to give you 7 days to pay. You have to give us time to update the ticket in our system. Okay.
$130 for 5 over.
Remind
me not to drive in Michigan.
At the counter, you can pay online or you can mail us a check. But when you go to pay, make sure it shows the limited access 130. If it's not updated, don't pay it. Okay. Wait till it's updated. Yep. Now on the mobile device, we've admit responsibility with explanation. And where's my fines? I forget what the
for all you Michiganites or Michigonians, is your courts just like ruthless? Like 1 to 5, that's like a $10 fine in North Carolina. I think it's 10, maybe $15.
Okay, so there's no motion on this, correct, Sergeant? I don't know.
Correct, ma'am.
Okay. So you've admitted responsibility. I find you responsible for the mobile device. That is normally $220. I'm going to reduce the fine to $150. How much time do you need to pay that, sir?
I could pay it today as well.
Okay, so again, 7 days to pay. Now listen, that mobile device, I don't know the law off the top of my head. You don't want to get that anymore. Get yourself a device, put your phone away, and drive slower. Okay?
Yeah, I've since got the little holder that goes on my dash, so I could just set my phone in there.
Good. And drive slower, and because we don't want anything bad to happen to anybody.
I will.
Okay.
All right, you may leave the Zoom. Thank you. Take care.
Thank you.
We're going to pause this just for a second because I want to show you who he reminds. This guy is like the spitting image of this dude. Let's do a little throwback really quickly. I think here we go. Let's go right here. Okay, it's sort of a lengthy throwback, but I want to take us there. Here we go. Audio on. Do you guys remember this dude that just appeared in the bottom right hand corner? Ernest Tonga. Tell me if he isn't channeling the exact same guy that we just watched in the other court. This is a Victoria Shackelford, high resolution. There we go. Give me a second. Let's skip ahead. And it has court watchers, like when I disappear here, the guy in the bottom of the corner and the guy sleeping on the couch. They're just court watching, and they have to log in and have their cameras on. That's how she runs things. It's like you can watch all you want, but you got to tell us who you are. We're trying to find the Boone hearing. I haven't been successful yet. Okay, come on. He wanders around for a little bit while she gets ready. So my kids are really loud. Hang on. Let's skip ahead just a tiny bit. Why is there no audio? Probably because I don't have it turned on.
About that.
Okay.
Sorry about that.
So
here we go.
1.1 for a period of 12 months. So you'd have some probation.
You have to back up. So you get his offense right here. All right. This is a throwback to
All right, Mr. Tonga.
Mr. Tonga.
Okay, this is 23-2778, the People versus Ernest Tonga.
This one's so good.
Morning, Honor. James Gazicki on behalf of Mr. Tonga. Waive reading, stand mute. He's going to plead guilty to the open intox, asking the court to take it under 771.
Sir, do you understand everything your attorney just said?
Yes, Your Honor.
No, you didn't.
All right. And you understand that open intox is still a misdemeanor?
Yes, Your Honor.
And it could get up to 90 days for that. You understand that?
Yes.
All right, I have to tell you the maximum, sir. Looks like there's a plea agreement that you would have a delayed sentence under 771.1 for a period of 12 months. So you'd have some probation terms for 12 months and then the case would be dismissed. Do you understand all of that?
Yes, and that goes as I'm a passenger too. I'm sorry for questions, but
what's that?
And that goes as I was a passenger too, so that applies still.
Did you talk to your attorney about that?
Yes, it does apply if you're a passenger.
Okay.
Yes, it does.
Sir, I can't give you legal advice. That's why you have an attorney. So
sorry about that.
Okay. So do you understand all of that?
Yes, Your Honor.
Did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, Your Honor.
Did you understand your rights?
Yes, Your Honor.
Mr. Tonga, sit down. You're making me dizzy. We're going to get through this. You're making me dizzy. All right. So you sign the advice of rights. You understand those rights?
Yes, Your Honor.
You understand if you enter a plea to this, you'll be waiving those trial rights. There will be no trial of any kind.
Yes, Your Honor.
All right. To the charge of open intox, sir, how do you plead?
Guilty.
Has anyone forced you to get you to plead?
No.
Has anyone promised you anything other than the terms of the agreement to get you to plead?
No.
Are you pleading guilty of your own free will?
Yeah. Yes.
All right, well, you're shaking your whole head no, Mr. Tonga. I have a whole book of court rules. There are questions I have to ask someone when they plead guilty. I'm not inventing these questions as I go. These are questions I must ask you. So, but I don't want you to shake your head no and tell me yes. I mean, this is a decision that you need to make, and I want to make sure that you're making it knowing and voluntarily.
Okay.
Just plead me guilty. I talked to him. Plead me guilty. I accepted all my rights. Just plead me guilty. I got 12 months, whatever, probation.
Who are you talking to? Who are you talking to, Mr. Tonga? Sit down. Sir, you had a chance to meet with your lawyer.
Yes.
Is that correct? Okay. Listen, do you want the plea or not?
Yes.
Were you in the city of Taylor on November 20th of 2023?
Yes.
Were you in a vehicle while you were in the city?
Yeah.
And did you have open containers of alcohol in that vehicle?
Yes.
Mr. Gazicki, are you satisfied?
Yes, Your Honor.
All right, I'm going to accept the plea as knowing and voluntarily given. He's going to be referred to probation so we can see if any terms are necessary or if it should be non-reporting. So, Mr. Tonga, you would be eligible for early termination under certain circumstances that the probation department will go over you and with you in more detail. But you're going to get a notice within the next week to appear for a probation interview. And after that, you will get a date for sentencing. Okay.
I'm getting probation out of all of this. Is what I'm getting.
Well, you have to meet with probation so I can determine what's appropriate for you.
I wasn't even driving, but all right. All right.
All right. You know, we're going to withdraw the plea. Mr. Gazicki, I'm not accepting the plea. It's clear he doesn't want a plea.
I don't understand what's going on.
No. I'm done. Mr. Tag, I'm done with you. We're not doing this. You're not going to be forced to plea. Mr. Gazicki, I want to make sure we have this. As to arraignment, how do you plea on behalf of your client?
Waive reading, stand mute, Your Honor.
All right. I'm going to enter a not guilty plea on his behalf. We're setting a jury trial.
Jury trial.
Okay.
So we'll get you a date, Mr. Tonga. You'll get a date of your jury trial coming up within the next few weeks, okay? And we'll see you on your jury trial date. The conditions of your bond are as follows. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're not to purchase or consume alcohol or illegal drugs, and you may be subject to random testing at your expense. Have you been fingerprinted, sir? Oh, he left. Oh, wait, he's back. I think he keeps getting, because that's happened before. Mr. Tonga, did you understand all of that?
I got kicked out. What do you say? I'm sorry.
You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're not to purchase or consume alcohol or illegal drugs, and you may be subject to testing for those substances at your expense. You can't drive a vehicle without a valid license, and you have a $500 personal bond. You'll receive notice of your next court date in the mail, sir. And you're all set.
So I didn't accept the plea, so I have another court date, basically?
Yeah, you do. You're going to trial.
For why? I accepted my plea.
Because I did not accept your Mr. Tonga, in order for you to plead guilty, I must accept your plea. And I am not accepting your plea.
I didn't know.
So I'll see you on your trial day. I will see you on your trial day, sir. You're excused.
Okay, so that was fun, but it's not over. You think it's over. It should be over. But we fast forward, we fast forward, we fast forward. More cases. And wait, who's that in the window again? It's Mr. Tonga. So let's back up just a little bit and see what happens here.
Told me that I was getting
You're all set. Give us what happened with Mr. Gazicki.
That wasn't supposed to happen. Hang on. Wait for it. we need.
So we're going to put you in so you can talk to the attorney on that. You have a separate attorney for the misdemeanor, okay?
William's still chilling.
All right, so we'll put you in with Mr. Gazicki.
Okay, thank you so much too, by the way. I'm sorry.
We'll be in touch, Mr. Banks.
I said thank you so much, by the way, because I'm sorry for like being late. I'm sorry.
Okay. Just, you know, when you've got cases like this, it's important. I don't like to issue bench warrants on people if I don't have to. But you're all set. Give us a second. We're going to put you in a room so that you can talk to counsel on your misdemeanor matter. Okay. All right, Mr. Tonga, I see you're back. My understanding is you've been cussing out my clerks downstairs. So what are you here for? What?
Yeah, I didn't talk to no clerk.
Okay. Well, it's a recorded. So they have a recording of you talking to them and cussing at them.
Right.
Anything else? Why are you back? What can I help you with?
I was wondering what was going on. The attorney didn't let me know what I was getting. So when he told me that I was getting probation for 12 months or whatever, it surprised me. So that's why I reacted the way I reacted.
All right, we're going to have an in-person hearing.
But I didn't know what was going on.
You're going to be here in person next Monday.
In front of the judge and the bailiff, who might both be me.
You're going to be here at 9 a.m. next Monday.
Okay.
Which is February what? 26th. February 26th for an in-person hearing at 9 a.m.
Okay.
226?
And that.
Wait, 225. Yeah.
Okay.
225 next Monday at 9 a.m. 25th is a Sunday. I'm looking at March. Nope. Hold on. Let's get this together. No, in February 26th. February 26th. Monday at 9 a.m.
When I was in the room and they said I was cussing, I was in the room by myself.
You're going to be here 9 a.m. in person next Monday for a hearing.
Okay.
And you're all set. We'll see you next Monday in person.
All right. I appreciate it.
Thank you.
Yep. I'm sure you do. Anyway, I was a little throwback. The guy we saw this morning he was a spitting image, and he was walking around the same angle of the camera. I thought it was the same guy, but turns out it was not. But it was fun to do a throwback anyway. I thought I'd do that. Yeah, everything not to say to the judge. He pretty much did it. He pretty much said everything.
I'd agree that everything you just said is one of the most horrible things I've ever heard.
All right. I don't know how his hearing went. We'll have to. I think it's done. I think it's done and over because I don't know when jury trial was. But let's jump back into to our court we were watching with that other judge. It's a Zoom court. We've got some more participants here. Let's see what's up with
the complaint. Was signed October 18, 2023.
He indicated to me that he was not aware of this warrant. I'm not sure why it wouldn't have popped up with his probation officer, although perhaps they just weren't going to run a lien until they were ready to discharge him. At any rate, he came into custody on this when he was riding his bike. The police stopped him. He gave them his name, and this warrant came up. I believe this was the only warrant. I don't think that there are any others, at least not that he's aware of. He indicated to me that if he had known about the warrant, he would have walked himself in on it. He's not currently working. He's looking for work right now. And so with that, I guess if the court is not inclined to set a personal bond, I'd ask for a nominal cash bond. He does know that he needs to contact his
What does a nominal cash bond mean to you?
Just something on a low end, Your Honor, perhaps
$5.
Perhaps 1,500, 10%, something along those lines.
Okay. All right. The court is setting a
2,000.
$1,000 cash surety, 10% bond. I mean, I may have been inclined to set a personal bond, but because he was out on a status, I'm going to set a cash surety, $1,000 cash surety, 10% bond. We'll set this matter for a pretrial. Nope. Let me see. This is a charge as a felony. We'll set this for a probable cause conference. No less than 7 days, no more than 14 days. We'll set this for a preliminary exam. The notice to appear will be sent to the Ferndale address. You'll have assigned counsel. And in addition to $1,000 cash surety, 10%. The bond conditions are.
Hang on.
You to personally appear for any.
Here's the Sarah Boone update. Hold on. Here's what we heard, and thank you, Greeners, for this. It happened very, very quick. I'm trying to find video of it right now, but it was extremely quick. We have a record in the court proceedings of what happened. Let's see, hearing 6-7. That's today. Per the court comments, status held. Defendant advised the court of her concerns with her attorney. She's not unhappy with the attorney again. Attorney Cashman addressed the defendant concerns with the court. The court took under advisement and will readdress prior to trial. The defendant provided the court with letter in open court. She gave another letter. We have another Sarah Boone letter, and unfortunately, they are super, super slow in scanning these. So it might be a week out before the letter that was given to the court gets added to the docket, and we'll have that. But it will be up. But if we can find a video that covers the hearing, it's like a minute and a half long. It's super, super short, and really she's probably saying the same thing we've heard over and over, which is, Judge, why won't my attorney spend 24/7 in my cell? Or something similar to that. But, yeah, she's... I do not think, Debbie, I don't think this is stall tactics. I believe 100% Sarah Boone wants her day in court, but she wants to have an attorney as well. There are so many opportunities, and she knows. She's been in jail long enough, years. She knows you can represent yourself. She doesn't want that, okay? But she wants an attorney that will represent her the way she wants to be represented, which, when you have a public defender, you don't always get. That's not how it works. Her attorney's phone doesn't work. Wow. I see we might be able to take some from Court TV here. Give me just a minute to see if we can watch the live part. Okay, give me just a second here. Do we have some audio? No.
Options. Number one, she can ask you to represent herself. She has the right to. You have.
We're going to see if we can bring this up. Let's go full screen.
We're at a hearing. The other thing is she gets one last lawyer and either works or it doesn't. And, and sometimes, unfortunately, the court gets put in a position that you have to have that conversation with a client that you don't, if you want your counsel of choice, then you need to hire your counsel of choice, and everyone can certainly do that. And
okay, so let me explain who we got. I believe that's Attorney Cashman that's speaking right now. I think, or maybe that's a new prosecutor. I don't know. Judge Michael Kranick, that's the new judge that's overseeing the case. This is the court. This is the proceeding with.
If you're indigent, the court can only go through this so many times with Miss Boone coming to the court, and there ending up being irreconcilable differences, such that the counsel that you have appointed can't move forward and provide effective assistance to counsel.
Okay, here's what we're going to do. I'm inclined to go ahead and figure out.
Patricia Cashman is right.
So I'm waiting for, I think that's live. We missed, I can't seem to get back to the the portion that that covered exactly what Sarah Boone said, because she did speak in open court, which is rare. Sometimes she's shown up and she hasn't been able to speak. But let's see, where is the? How can we find? It might be a bit before that video becomes available. Anyway, she's gone through a bunch of attorneys and she's not happy. She's still upset. She doesn't like the way she's being represented now. At what point do you finally say, it's not them, it's me? Right? Cashman is her attorney right now. I'm just going to pull up her docket. Just give me 1 second. This is Orange County, Florida. And it's Sarah Boone. I'm not a robot. Here we go. All right, the latest we have on the docket. We've got a trial date set for 10/7, or at least a hearing for 10/7 is the latest.
From
Nate, or sorry, Thal.
To accept, press.
Thal, I got your text, and just know we're not going to talk about it. Is that all right?
Well, of course not. No. I'm willing to talk about the what we were texting about last night about the hung jury.
Okay, we can do that.
Yeah,
good to hear you.
Yeah, there's
read it, by the way.
Thank you. Yeah, no, there's lots of things I know that we can't talk about.
It's not that we can't.
Lots of things I like to. There's lots of things I like to message you about that you're like, okay, that's great, but don't bring that up on.
on my phone it says Thal NSFW next to it. That's how I'm going to say it.
And if anybody in the audience is wondering why me and a Recovery Addict.
Oh, sorry. Hang on, I cut you off just one
because
second.
Recovery Addicts would like to have a nice long career.
Yes. It's self-preservation reasons that we're not sharing everything. And now you're just making everybody
exactly.
curious.
I'm fully willing to admit that.
Yeah. It's selfish self-interest.
But no, oh yeah, no, absolutely. It's self-preservation. And here's the thing: is I'm totally behind it. I totally get it. I have a big mouth. I'm a funny dude, but yeah, I see stuff I shouldn't sometimes. So, but that's the charm. It's part of the price you pay. No, the thing with the hung jury though for me was just exactly. The thing with the hung jury for me was that we didn't have direct evidence and that's kind of what I was saying throughout the trial in the chat was that we didn't have. I didn't have a bloody footprint, or I didn't have like a go-to murder weapon, or and when it came to the car moving the seat back, I thought maybe we had some wiggle room there. But the problem was the defense brought up, well, he checked the car after he got there. Mm-hmm. And I'm thinking, well, if he checked the car and he sat in the car and he's that tall, of course he's going to move the seat back because he can't sit in the car all crunched up. So I'm like, yeah, so that might get defeated there. And apparently it was. So yeah.
And when you have a case like that, you're going for murder one, which requires proving premeditation, and all you have is circumstantial evidence. How do you get there?
Yeah,
How do you get to here's where he planned it out with only circumstantial evidence, and that's a big reach.
Well, and I think the prosecution, for me anyway, the prosecution harped on way too much about the dude being a creep. You know what I mean? Mm-hmm. We got that from one witness.
And
we
that's
got
not
that
illegal.
he was a creep.
It's not illegal to be a creep.
No,
Otherwise,
I
most of
totally
the people
agree.
I know would be in jail. But no.
Yeah, I'd serve 1,000 years for not shutting the hell up. So.
But no, it's. I've never seen, and I realize if I had just listened to the instructions, it wouldn't have been a surprise. But in the jury instructions, apparently the judge told the jury he would do exactly what he did. And he would be going over and finding exactly where their point of disagreement was. And because they did agree, you have a jury that agreed on not guilty on first degree. So he declared not guilty. What that did, it's a huge benefit to the defendant. And it sort of offsets the unfairness of having lesser includeds in a way.
Mm-hmm.
Okay, because a lesser included, it's like, well, I can be tried for, they're going to get me for something. Okay, if they say no on all the rest, finally they're going to be like, look, oh yeah, he's a creep. Let's get him for involuntary manslaughter or something. That's like, you're just throwing everything at the wall to see what sticks. But the way the judge does this, and he says, okay, not guilty on that, it's gone. He can never be tried again for first-degree murder of Karen Swift. You can't. That would be double jeopardy. It's gone.
But unless new evidence is found directly tying him to the murder, and then they can do it again. But there has to be new evidence found. This is the way I understand it. I might be wrong about that.
I think double jeopardy is pretty solid on that. I don't know. Maybe if he admits to it, I don't know. It's a high bar, as Mr. Repertorso said. It's not as easy to do. But anyway.
Okay. Well, Chat's telling me I'm wrong, so I'm probably wrong. I'm going to run with Chat's wisdom. Yeah. That way, if Chat's wrong, then Chat's wrong. I'm still not wrong. So there you go. I'm using Chat as a shield.
Yeah. No, that was an amazing case. It was interesting. It's tragic because the further we go, the more it just looks like the family once again is not getting closure. And you've got his kids who don't see him as the culprit. They don't see him as the murderer. Right? They're standing by their dad. They're testifying for their dad. So they're grieving their mom and wish there was justice, and at the same time they're getting the other side as being the child of the defendant. It's terrible for them. And two of them.
Oh yeah, well, and that's the thing too, is that the I kept saying this in chat I just kept shaking my head because if I was this dude, and it might be different because I've never been married. You know what I mean? Nor am I married now. I'm single, ladies, in the chat, just in case you're wondering.
Swipe left. Just go ahead.
No, break the phone, walk away. That site is doomed. Don't even bother swiping left. Everything else is trash. If I'm on there, everything else is trash. Just run. Just run. No, but
Beyonce's gonna
there you go.
Strike us here.
But yeah, no, the thing about what was I gonna say? The other thing about the murder charge, right, was that the fact that if I was him in that marriage, as soon as, and again, I'm not married, so I don't know, but as soon as my wife said, I'm going to a party and you can't come, and treated me with a disdain of, and I'm still going, so we're done.
We're done.
Yeah, because I'm giving you the paper that next day. Because here's the problem. It's not about you going to a party without me. It's almost got nothing to do with what my decision there is. It's the fact that you have utter disregard for me. That's my problem.
I'm sorry, Thal. Chat has questions.
Okay.
Can you cook? I'm interested. Come to Texas.
Yes. Yes, I can cook. I can travel too. I'm retired.
There you go. Financially
and I'm only
financially independent. Do you hear that, ladies?
And I'm only 47, so I'll give my real age out there. So
he's just
the younger
child.
ones don't get confused.
Yeah.
There you go. But yeah, no, yes, I can cook. I went to Job Corps, took culinary arts for 11 months.
Mm-hmm.
So I can cook really well.
There we go.
That's about it. I'll make you laugh.
I've never been
funny.
matchmaker before, and honestly,
so if anybody's wondering if I'm good looking or like really strong or really athletic or great in bed, I'll make you laugh.
I'd agree that everything you just said is one of the most horrible things I've ever heard.
All right. On that note, Paul, it's good talking to you. We've gone off the deep end. We're going to jump back into court. We're going to watch Judge Simpson.
Damn it! I did it again.
You
so good at it.
Paul, have a great weekend.
Right, I'll talk to you later, buddy. You too, buddy. Bye.
always makes me regret taking phone calls. Here we go.
Date and time set for final settlement conference. At this time, you're unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you.
He's the guy. In this case, I think we have to play this.
I don't think that's him, Mark. I don't think that's him.
He doesn't want the tether anymore?
He does not.
He doesn't?
No.
Really?
Doesn't want the tether?
That was my gift to him. He's re-gifting. It was her. Sensitive. Court calls the case, People versus Aaron Finley.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Finley. Mr. Finley, please state your name for the record.
Aaron Finley.
Your Honor, today is the date and time set for final settlement conference. I have had a conversation with Ms. Barroso, and I suppose the plan is to dismiss the misdemeanor as it's been reauthorized as a felony.
I do believe that you have the felony file in front of you, and I would be asking that you arraign him on that today.
All right. Your name, sir?
That did not go well for the defendant.
Finley? You are before the court. It's my complaint here. Right? Is there a reason why it wasn't printed out? You are before the court on a complaint that alleges that on or about December 1st, 2023, location of 3127 Scenic Lake Drive, Pittsfield Township, Washington County, State of Michigan. Count 1 alleges that on that date and at that location that you did assault with the intent to do great bodily harm, less than murder by strangulation, the individual known as Lindsay Forbes. You understand that charge, sir?
Ooh.
Do you understand that charge? Yes? You're going to verbalize for me?
Just need to speak up.
Yes.
That is a felony. It is punishable by up to 10 years incarceration and a $5,000 fine plus court costs. It would require your DNA be taken upon your arrest. A consecutive sentence is possible under statute if the assault took place in a place of confinement. You understand the maximum penalty, sir?
Yes.
Count 2 on that complaint alleges that on that same date and at that same location, you did interfere with electronic communication, causing injury or death.
We took her cell phone too.
Right. Causing injury or death. You understand that, sir?
Yes.
That's a felony, punishable by up to 4 years incarceration and a $5,000 fine plus court costs. You understand that?
Yes.
Count 3 on the complaint alleges that on that same date and at that same location, that you did commit the offense of domestic violence upon Lindsay Forbes. You understand that, sir?
Yes.
That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and could be subject to a consecutive sentence. You understand that?
Yes.
First question I have for you is, do you want to be represented by counsel?
You have to answer out loud. That's the way court works.
Public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Finley.
I need 8.
We waive any further reading and stand mute to the charges, Your Honor.
Sorry. Send in every way form of reading, standing mute. Court will enter a not guilty plea. Court will set this for probable cause conference. You're demanding that, is that correct?
Yes, Your Honor.
We'll set it for probable cause conference on the 20th. 2024 at 9 a.m. And then a preliminary examination would follow from there. As to bond.
We are asking for bond to continue the same bond as the misdemeanor file. Mr. Finley has been on bond for quite some time. He has had no violations. In fact, he lives on Flint, so he does live away from the complaining witness. He has had no contact with her. He's been compliant with the court's orders. He's been here for every court date. Bond is working as it should be.
Why is the bailiff in position behind him?
He has significant family support. His grandmother is here with him. His sister, he lives with his sister. She is also his guardian. And I've had multiple conversations with her. I know that she's very involved. and ensures that he gets to court and does what he needs to do.
Does he?
He does have another case in Oakland County that's scheduled for pretrial on Tuesday.
And the case is
and the plan there is there has been an agreement that file is going to be resolved on Tuesday, and then I don't know what the resolution is, but
on a CSC, what degree?
Most of the degrees have been taken down. It's just a 3rd degree right now.
It's a 3rd degree. Okay, go ahead, Miss.
he has been out on bond in that case. Obviously, Your Honor, he is with us. And again, there has been a resolution in that file.
Does that CSC involve the same person in this case?
No.
All right. From the people.
I do not rely on interfering with communications was not authorized at the outset, but immediately upon review of this file, I've submitted a request to have this reauthorized as a felony. I do not believe that the bond that is currently set is appropriate in a case to this degree. However, I understand that the defendant has been out and has been compliant. To the best of my knowledge, I will say I don't know when the allegations in the CSP occurred, if that was after the initiation of this case, or if that was prior to the initiation of this case. But at this point, I will do this discretion. I have last year. When was your first appearance?
Lots of people in court here.
When did
look at that big red bow?
The CSC? When did
criminal sexual conduct?
He's indicating that he was first arraigned in 2022 on that case, so it's an older case. I don't have the date of offense.
But okay. But the problem is that he was on bond on that case when this case comes up.
Yes.
I'll recap Boone in just a second. Let me just let this one resolve here. We're going to follow Judge Cedric.
To your knowledge, was that addressed by the magistrate upon arraignment and the other matter?
Yes.
If you give me 1 moment, Your Honor, I can check our notes.
Okay, while they're doing that, I just want to say a big shout out to
no, Your Honor, because there was no indication whatsoever that that case was ongoing, and he has no convictions on his record. So my understanding is that we did not note that in our bond form. So it would not have been necessarily argued by the APA.
Big shout out to Day on the docket, who's doing some digging for us, getting information on Sarah Boone on that hearing. We have a link to Day on the docket on, I believe it's your X. If you're on Twitter,
residing at the Flynn address.
If one of my mods can post that in chat, that would be awesome.
Right. I'm going to indicate that you are not setting your bond. If you are not to use or possess any alcohol, marijuana, or any illegal drugs. Going to indicate you're not to leave the state of Michigan without permission of the court. You understand that, sir? Yes. You're not to purchase or possess a firearm, ammunition, or other dangerous weapon or anything fashioned to be a weapon. You understand that?
Yes.
You understand you're not to assault, terrorize, frighten, intimidate, threaten, harass, or molest or stalk anyone. You understand that? Yes. I will also order that you're to have no contact with Lindsay Forbes except with a civil standby with the police. You understand that? You are also not to attempt to have any direct or indirect contact with that individual in person or through others, or by any electronic communication, including but not limited to phone, email, text, internet, or any social media. You understand that?
Yes.
I will also indicate you're not to go to the 3127 Scenic Lake Drive in Ann Arbor, Michigan, except with a civil standby with the police. That is not your home address. Is that correct, sir?
Yes.
I'm also going to indicate that you are not to violate any criminal law and you're to personally appear at all court hearings and other places as directed by the court. You understand that?
Yes.
Well, a couple of things, and I understand what the magistrate may have been taking into account in setting the original bond, but if there's no knowledge of a CSC pending, when you say that's going to be resolved, is it going to be resolved to your understanding by way of a plea?
Yes, there's a plea agreement.
Well, the court's concern is that the defendant was, Ms. Barroso, were you going to say something to the court or?
My understanding, Your Honor, is it's 2 counts of CSC first, 1 count of CSC second with a victim under 13, and then 1 count of child abuse and commercial activity. That was what was charged. I don't know of any resolution, but according to Oakland's website, there has not been a resolution entered yet.
That changes everything.
He just had a pre-trial on the 28th
of
May and is set for another pre-trial on the 11th.
More perplexing to the court is that the defendant was on bond on that case when this case allegedly occurs. That's a problem. And both being crimes of violence, that's a problem. I don't believe that the bond, the magistrate could not have known that that other case that he was on bond on those other serious capital felonies at the time of the arraignment. And if she did know that at the time, the court would consider the setting of a personal or cognizance bond to have been an abuse of discretion. So for those reasons, the court, in ordering everything that I've ordered, will set a monetary bond in this case. His monetary bond will be set in the amount of $75,000 cash surety. Defendant's remanded. And as to the other matter, case ending in 0125, that case is dismissed.
So I was saying, day on the docket, a great Twitter account, no drama, just
anything
paperwork,
else ready?
court paperwork. If you want the latest and greatest, that's what you're going to find. So
I don't think so, Your Honor. I think the rest.
I followed it. If you
After what?
If you're on Twitter and like that stuff, I suggest to follow.
You're trying to work out. What's that mean?
I would like to have another.
Never mind. Okay. Never mind. I don't want your answer, Mr. Fairney. All right. Now, because it's going to be close to the same, I'm not going to like either one. All right, then I'll step off, and as soon as my staff lets me know that there's stuff ready for me to do, I'll come back on. All right, court is standing in recess. All right.
Okay, we're going to keep an eye on Judge Simpson to see what happens. He's one of the few judges that are active right now. We may have something happening in Thurston today. There was quite a bit of activity in Thurston County, Washington. Of course, they'll be a little bit later to get started because they're on the West Coast. But keep an eye on that. Not sure, I haven't looked at their docket at all. But let's jump back to our previous court that we were at.
Oh, he's calling.
She's holding up a sign that says "Please call" with her phone number.
Is that how it works?
Well, that's how dating works. That's how.
Can you hear me, sir? Okay, can you make it louder? The speaker. Okay, this is the day and time. Can you tell me your name?
Let's take the top end off this sound.
Okay, Mr. Awad, you joined the Zoom late, but did you hear when I called and explained what happens in an informal hearing and what your rights and options are?
I did not. My apologies for coming in late.
Okay, listen, because you can see all the people in the Zoom. You have 3 options. You can admit responsibility to this ticket of driving 1 to 5 over. It goes right to me to assess fines and costs. You can admit responsibility with explanation. That's where you say to the court, I admit I did what the ticket says I did, but here's how or why. When you give your explanation, talk about what you've learned, how respectful you were or were not to the trooper, what caused you to meet the trooper on the side of the road, and what you've learned. The trooper is cloaked with discretion to make a motion to amend the ticket as written, although there's no automatic. So know that if you admit responsibility with explanation, you may exit the hearing with the ticket as written. I have no power to order or to give any breaks. The motion must come from the trooper. The third one is where you deny responsibility. That's where you say to the court, I didn't do what the ticket says I did. I swear in the parties, I take testimony. That's an all or nothing deal. You either exit the hearing with the ticket as written or with no ticket. By proceeding today with an informal hearing, you give up your right to be represented by an attorney, to have this matter heard by a trial judge. I'm only a magistrate, and or be represented by an attorney. What is your choice?
Plead guilty with explanation.
All right. What would you like the court to hear? What would you like the trooper to hear, rather?
Trooper was great. He was very, very nice. Probably one of the nicest troopers I've ever dealt with. And I mean, I'm pretty sure you have my record open and you see.
I have not reviewed your driving record.
Oh, okay. So that's great.
That's
but no, I've definitely, I've had my past with my driving record, and I'm sure that the officer is aware of that. He looked at it when he pulled me over, and I've been doing very, very well at rectifying it for the past 3-4 years. I'm doing the best that I can. I was on my way to prayer during Ramadan, and I honestly didn't even notice the speed. I was just cruising with everybody that was on 696. I know that's not a valid excuse.
Yeah, the speed limit is 70. The speed limit is not what everybody else is going. We can only pull over one car at a time, right? You can only pull over one car at a time, right, trooper? We can't do like mass pullovers. All right, go ahead.
I just didn't know if it had points or it goes on my insurance at points. I'm trying my best to keep everything to a minimum, so I'm able to. I paid my due. Insurance was $15,000 a year. I've done it. I just don't want to go back to that level. So
okay.
I'm gonna receive any insurance points or anything like this. So if there's anything that we can do, but I completely respect your decision that whatever you make and
okay,
you continue to go forward.
Okay, trooper, having heard all that, is there anything you would like the court to consider?
No, Your Honor, there isn't. Mr. Awad, I wrote you a 1 to 5 over unlimited access freeway. This is 0 points. It's just gonna be a fine. So I'm just gonna leave it at that. I cut you a big breakout on the roadside there with this ticket, I think. So.
Okay, yeah. So he wrote you for limited access 1 to 5 over. It is a moving violation, but it is 0 points. But I did not look at your driving record, okay? But what you're saying to me, you have a complicated past, and you say you're trying to rectify it, and you don't want to get back to where you were paying high insurance. So the officer did you a great favor on the roadside, but it just seems common sense to me that the way to avoid your insurance going up is not to drive in the 90s on 696. Like, I mean, if you were going 80 or 75 and the ticket was actually written for what you were going, I would be like, that's in the realm of reasonable. But when I see that the remarks are that you were going, I believe it's 98. That's not trying to be a better driver. That's thumbing your nose, and that's just disingenuous to say that you're trying and you don't want to go back there, but you're going to drive 100 in a neighborhood where I live and drive and my staff drives. So you need to slow down. The officer gave you a great break on the roadside. So I find you responsible for limited access. The fines are, it's 130, right? $130. How long do you need to pay that, sir?
I can pay it online.
Okay, I'm going to give you 7 days to pay. Okay, but it is 0 points, but it does abstract, and it is a moving violation. Okay, please slow down. All right, thank you so much.
Soundbite.
Trooper,
Please slow down.
I think that concludes all your tickets.
Okay. Thank you, Your Honor.
Okay. I mean, do you see any more or no?
I've got one more for a Sora, but I don't see them in the waiting room, or I don't see them in the.
Okay, I don't have anyone by that name.
Okay.
Okay. Thank you so much. Take care.
Thank you. Have a nice weekend.
Yeah, thank you for helping our drivers out.
Of course.
Income
Okay.
Sergeant James.
Trooper James. All right. Do I have any criminal matters ready?
He's like
I
a
don't.
sergeant to you, man.
Okay, Trooper James, I'm going to try to knock yours out like really fast.
Thank you very much.
What?
Thank you very much.
What time is my in custody? 10:30. Okay, I have to go to the Oakland County Jail, like virtually, not really there, at 10:30. Okay, so I'm going to start and go as fast as I can.
Okay.
All right, I'm calling the 10:01 docket for traffic hearings with Sergeant. It used to be Trooper when I started. Now it's Sergeant.
Yep, that's quite all right.
Sergeant James. Okay, so everybody listen. This is the order that your cases are going to be called. Wesley checked in first, then Gelbert, then Adams. And I don't think I have, Ackroush is not here yet. Okay, the Trooper James, we have on our docket Ackroush, but it looks like he paid the ticket, so I don't think they're appearing. All right.
Sure.
So the order is Wesley, Gelbert, Adams. All right. I'm going to call the first case Wesley's case, but I need everyone to listen because my introductory remarks apply to all of you, and it would help speed things up and get everybody out here faster if everybody listened, and then I don't have to repeat it. Calling the case number of SP 4360449. This is the state of Michigan versus Timothy Allen Wesley. The first thing I do is ask for appearances, and that means tell me your name. We always start with the sergeant. Go ahead, sir.
Good morning, Magistrate. Sergeant Stephen James, Michigan State Police, Metro North Post.
Okay, defendant driver, your name?
Good morning, Your Honor. Timothy Adam Wesley. I know you mentioned Ellen, but middle name is Adam here.
Oh, it's probably just my voice. Okay, yeah. So I have a raspy voice. Sorry. All right. This is the date and time set for your informal hearing on your traffic citation. Every driver appearing this morning has three choices. One, admit responsibility. It then goes to me to assess fines and costs. I've yet to have a person make that selection in an informal hearing. Number two, admit responsibility with explanation. That's where you are admitting you did what the traffic ticket says you did, but you have an explanation. The explanation that you give is for the benefit of the sergeant, because only the sergeant on behalf of the people of the state of Michigan has discretion, and he's cloaked with power to amend the ticket to something else. The ticket may be less points, less dollar amount. Okay, some things abstract and go on your driving record, some things don't. Okay, that's between the sergeant and you. I cannot force him to give you a deal, even if I like your explanation. I can't order him to do anything. Okay, if you give an explanation, you should show
we've got a lot of questions
what
about
happened
Boone.
that day that you came to meet the sergeant on the roadside.
We'll jump back to court hop in just a minute. Let me see if we can bring up Boone. We might actually have a link to the video back. It happened very quickly this morning, but I want to tell people what happened because it's eye-opening. Give me just a second. Here we go. Let's see if this one works. Okay. I'm trying to pull it up. Send that to my MacBook. So Sarah Boone had a hearing this morning in front of a judge. She was there in person. She was there with her lawyer. Her new lawyer is Attorney Cashman. Let's see. Trying to see if we can get her part where she speaks for you. Let's give this a try.
Conference that I
First and foremost, Sergeant James,
I'm not sure what that says
never had
about
a ticket
the
or
attorney-client
anything like that.
relationship.
So really a first.
We've got two feeds going simultaneously. Sorry about that. Pause that one. There we go.
Seeking to have me take a look at.
It's things that I've been working on in the meantime. It's things that she likes to tell me is not necessary, but I know for a fact it is necessary. She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she's supposedly representing my life.
Okay. Give me an example of, if you could, of items that you believe are important. Ms. Catchman is not giving attention to or dismissing as you may have framed it.
Yes, Your Honor. She likes to tell me that I don't like her answers. She's not giving me any answers to this. I've written 3 pages worth of questions, and I'm still waiting for her and any other attorney to actually answer for me, such as, why can't I have a bond? Why can't I have a download of my phone? Why can't I speak to my investigator? Why can't I have my medical records? Why can't I fully utilize my constitutional rights? There's 3 pages worth of questions that I
What constitutional rights specifically?
I'm very leery about having a fair trial at this point. There are a handful of other amendments that I have been researching and working on and trying to incorporate. To me, what I have written to you is obvious, and apparently from the correspondence that I get from the world, South Korea was the last place that I received correspondence. They obviously do the same thing. So I don't know what I'm doing wrong other than wanting to have a very successful outcome. It's just been long and drawn out, and I believe that God obviously will consider me as much as I do him in order for him to give me this very unique adventure that I am on, and I'm doing my best to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me and have a welcoming attitude, and things will probably change, and I will not get up and I walk out. Please don't lie to me. Please don't give me half-truths. And
What instances where there's been falsities or lies that have been told to you by Ms. Cashman? Can you give me an example?
my biggest one, Your Honor, is for me being here ongoing 5 years, no one has ever bothered to try to get me a bond.
What's the lie? You said that she has lied to you. What is the lie?
The process of getting a bond. She lied to my brother in regards to telling him that he would need to come down to the courthouse to have multiple photographs taken for documentation. He would have to bring security information, leads to his house.
Lie. There's
Okay.
so much to
Okay. So there we go. That's what happened this morning with Sarah Boone. She is not happy with her lawyer. She's upset with her lawyer. She is says she's been lied to. She doesn't like the attitude, a snotty attitude. She has a hand delivers a letter to the judge to make sure he gets it, because she's alleged that there are problems with things going back and forth before. So hand delivers a letter to the judge. When you do that, it goes into the record. The judge stamps it. He will read it. It will go into the record, and he'll consider that, because she's basically saying, the lawyer you assigned to me, judge, is garbage. Attorney Cashman is garbage. She's gone through everybody. I mean, they're literally seeing who hasn't had Sarah Boone assigned to them, or isn't conflicted on the case, and that's all that's left. So I think she's sincere when she says she wants a new trial, or she wants her trial to go forward. It's been close to 4 years now that she's been sitting there, I think, if my math's correct. It's hard to tell because she has like 2 birthdays a year, I think. Sounds like the lawyer is doing lawyery things, and that's good, but she doesn't like the way it's happening. She wants somebody to listen and see her as what she is, instead of the murderer that she's portrayed as. She's getting letters from all across the globe, the last one being from South Korea. Apparently she reads them. I'm not sure if the letters are fan mail or hate mail. Probably a mix of both are going on. I don't think she's trying to delay. I really think she thinks that if she can just get her story out there, that they will acquit. They will see that she's the best at everything she does. So we'll see if we can get any more footage from that hearing. If we do, we'll bring it to you. But there will be a letter. We'll keep our ear to the ground. There will be a letter posted, and we will bring that and read that to you once it does come out. That's the latest and greatest in Sarah Boone. Other than that, if you look at the docket from the court, the next things that happen in Sarah Boone's case, we had the hearing today. On 9/24, there's a hearing. That's a trial management conference. Okay, that's good, because that means we're moving forward closer to the trial dates. And then there's the trial. Currently, it's scheduled for 10/7. So that's going to be a fall trial, and I hopefully she gets that. We don't want this pushed out into Brian Koberger, Corey Reed grounds, or Corey, not Corey Reed, Corey Richens. Anyway, we're waiting for Judge Simpson to come back. We're going to follow him a little bit this morning. We can also go back to the court we were in just a moment ago with some traffic offenses, driving 98 and a 70. That's not good. It's not good. Slow down. October trial with her 12th lawyer. This discussion comes up, and we heard just briefly her attorney had this discussion, or possibly the prosecutor had this discussion with the judge, saying this is an option, and it might be the only option left, where she ends up representing herself not because she wants to, but because there's no one else to. And the court says, look, if you won't take our attorneys, if you won't work with our attorneys who are talented, hardworking, professional attorneys, then you're going to be on your own. I don't know how that works, because you have the right to an attorney. We'll see. Let's see if we can get a little more. See if we get a little more out of Sarah Boone here. Just 1 second. Waiting for they tease the video. Let's see if it works. Sarah Boone, of course, is accused of killing George, her boyfriend, by zipping him in the suitcase and leaving him there overnight. And then 11 o'clock the next morning, she went looking for George. Like, oh wait, he's still where I hid him in the suitcase. He never came out. Joy girl, welcome. Good to have you here. I don't think they offered her a plea. Just waiting to see if we have any more video from court. And you can tell I'm stalling. They keep teasing that they're jumping back to court, so we hear a little bit more. Wait for it. That's me. I hear myself. Wouldn't there be an automatic win on appeal? Yes, I think so. But it would just be a new trial, though. It just stalls it. We're going back to court right here. 3, 2, 1.
And then it turns into all these other different stories of why she won't do or why she has said certain things. And all this changes and it mutates after I ask her for certain things, not just for the bond, but for other things also.
Okay, well, let's focus on the bond issue because you said that she's lied to you, and what you've told me so far, none of that is inaccurate.
So how is it though, because I don't have any experience prior to this, I don't know the process of getting a bond other than what I have read, and it's just for her to do a bond, a motion for a bond hearing. But I didn't know that anyone, all of the other inmates, even officers, have ever said that they've had to do that process in order to have photographs taken, documented, and news crews, and visit to his house. He's not posting my bond, which I told her a million and one times, but she still spooked him by asking by him thinking that he's going to have to, and it would threaten his security clearance considering he's in the service, the military. So she totally deterred me from having my brother's address in order for me to have a motion for a bond. No one else has even bothered to even ask me for one, and I will be honest with you and the court. I know for a fact with however sky high my limit would be for my bond to receive, I know for a fact unless my fans would set up GoFundMe pages or God's will or however else it is he planned on for me to have it paid, if at all, my point is to utilize my rights to have a bond. And with the information I have
Her fans would pay her bond.
for the amount of saturation of publicity, there's nowhere that I could go even if I were to be an in-quotes flight risk because of the amount of information that everybody already knows about me, what I look like, and what I eat apparently, and so many other things. There's nowhere I could go if I were to even think about being a flight risk. It's just the fact that I would like please to have a bond so I can say that I actually achieved something.
Okay, so she just goes on. The clips are cut up. We're grabbing what we can and going to analyze it. She says she wants a bond. This is what she's after. She'd like a bond. She says her lawyer has prevented her from getting contact information of her brother, which is what she needs. He needs to come down to court and show several forms of ID and go through this whole process, jumping through hoops so that she can get a bond. But she doesn't think he can do it because that would, hang on.
I mean, he's been in the courtroom for all the hearings, and it's likely that they would be here for the bond hearing, that your face could be on the television, and it was a concern for him. And
security clearance.
I'm gonna just leave it at that. But Judge, I can't spend all my time defending what I'm doing and at the same time be effectively preparing a case for trial. In these situations, I know it puts the court in a very difficult position. As I see it, Ms. Boone has a couple options. Number one, she can ask you to represent herself. She has the right to. You have a Faretta hearing and determine whether she's capable. The court then has to address the issue of whether it's appropriate to appoint standby counsel. Obviously, since she believes not a word that I say after 40 years of doing criminal defense, I'm probably not the right lawyer for that. The other thing is she gets one last lawyer and either works or it doesn't. And sometimes, unfortunately, the court gets put in a position that you have to have that conversation with a client that you don't, if you want your counsel of choice, then you need to hire your counsel of choice, and everyone can certainly do that. And if you're indigent, the court can only go through this so many times with Ms. Boone coming to the court and there ending up being irreconcilable differences such that the counsel that you have appointed can't move forward and provide effective assistance to counsel.
Okay. Here's what we're going to do. I'm inclined to go ahead and figure out.
Patricia Cashman.
Okay, so here's the update. What we have there, that clarifies the bond issue. At the bond hearing, her brother would have to come testify. He has a security clearance, and his face being shown based on what he does for work, I don't know what that is, would be jeopardize his security clearance because of the public viewing and all that. So that apparently is a problem that way. Her lawyer is saying, I'm doing everything I can, but really the best thing on the table is for her to represent herself, because even in her own words, I'm not the best attorney for this. What she wants her to do, she can't do. So that's where we are so far. These are the updates as they happen, giving you the pieces that are available. The big thing is she says that she wants a bond, and she says her fans would pay for it. She doesn't have money right now. She would not be able to pay.
The first full week of August, and it starts again on the last full week of August. So we could set it then, but I know that you have trial case management with Judge Marquez on the 20th or the 21st of June, which may impact that.
And I have a trial certain with Judge Harris August 5th, and
as do I.
August seems a bit difficult for me.
For a week for Mr. Robinson. So the options that I see it are, we could specially set this for the week of August 26th, or we set it for the trial period beginning September 30. The hiccup with that first week of September 30 is we have a court holiday on Thursday, October the 3rd, which would limit us to a 4-day trial period, which I don't believe is not sufficient. So that would take us to either October 7 or October 14. So based on the court's trial calendar, that's what I've got available. August 26th, October 7 or October 14th.
I think the October 7 or October 14th is more realistic, Judge. I know that Mr. Cacciatore has other trials too, and other things on other judges' pretrial dockets and those things.
We're specially set in July and in September. Mr. Cacciatore?
I think we can, I think October 7th is fine.
Okay.
October 7th is the date for trial.
We're going to specially set this matter for the second week of the September 30 trial period, beginning Monday, October 7th. We will set this matter for trial case management on the 24th of September, right? On September 24 at 9 a.m. Oh, yeah, that's a good idea. We'll do you at 1:30 in the afternoon.
Okay, so this is the judge scheduling
Tuesday, September 20.
Tuesday, September 24 at 1:30 in the afternoon for our trial case management. Trial date certain on October the 7th. Deputy, if you could please grab the 2 packages of submittals from Ms. Boone. Oh, I thought it was 2 different envelopes, ma'am. Okay. I will review that, and after the review, the court will either issue an order or set this matter for hearing based on what it is that's been presented by Ms. Boone. Mr. Cacciatore, anything else we need to address this morning, sir? Ms. Cashman, anything else we need to address?
Not that I'm aware of at this time, Judge.
Ms. Boone, is there anything else you need to bring to my attention at this time?
I'm grateful for your time. I forgive you for having to utilize it. But I really do hope that you review thoroughly what it is that I'm asking for from my attorney who's supposed to be representing me for the trial that's supposedly happening in October, late September. So if you could please, I don't understand how I'm supposed to be able to go into a trial when I don't have what it is to properly defend myself.
Ma'am, I've asked for your submittals. I will be reviewing them. All right, thank you. All right, y'all, thank you very much. Have a great day.
Thanks, Judge.
All right, and with that, Sarah Boone hearing is over. She leaves the courtroom. She handed a packet to the bailiff, or she brought a packet of information for the judge, which has been going to the bailiff. The bailiff is reviewing it right now, and then we'll present it to the judge. The judge says he will review it. It will, because it's communication with the judge, it will be stamped and scanned into the record. It's going to happen. It's going to be there. So now we have to watch for that. Josh says, check the burner. Let's see. It's just photocopies of her past letters. I think there's going to be something new because she has to say something about this letter. Let's see who has this one. Oh, it's a new court? I think we watched him before. What, was there something specific about that, Josh, you need? Or is that just one you say we should watch? It's a felony trial in a Zoom court. I think she said 2 letters, 1 packet. Or there's at least 2 items in the packet. It's a handwritten, handbound book of all her letters. She says that she has fans. That not only does she have fans, that her fans would pay the bond, whatever it is. The fans would come up with it, and they would be able to. So she says, if I could just get a bond hearing, doesn't matter what it is, I'll get out. I'll get out on bond because my fans will pay for it. They'll set up. She says they'll set up a GoFundMe or something. It's going to happen. It's going to happen. Drug trial, pro se defendant. The trial started today. Josh, let me take a peek at that really quickly. See if I can bring it in over here. Judge Cedric's not back yet, so let's see what we can find.
Call from Welsh Lady.
Welsh Lady. Welsh Lady, how are you doing? You got to turn your sound down a little bit.
Yeah, I just muted it. You know me, I always have the telly on in the background.
Yep.
Hello, how are you?
I'm doing really well. Happy Friday to you.
Happy Friday to you as well. Well, what's happening with all these cases, eh? We've got the Karen Reid one, which I know you're a bit behind on because of Brandy, which you much respect for that. And Ask Crazy. And now Sarah Boone's coming out with another letter. I thought I was nearly done with her letters, Scott. Now I'm going to have another one to go through.
At least one, possibly 2. There's time. Usually it's been a couple months between letters. There's still time for 2 letters.
It's been a while, see. She's done 12 altogether, I believe. And I've done up to number 9, I believe. So I thought, oh, I only got another one to go now to do 3 letters. And I'll be done. But oh, it's funny, mind, when you read them all back. But hello, chat. Hello, everybody. It's nice to see you.
Welsh Lady, I have to ask, are you one of Sarah Boone's fans that would pay for her bond?
I am not. Right, now listen, I've had to apologise to her. Right, now this is the thing, right? Regardless of my opinion about people in suitcases, right? And putting them in there and playing hide and seek and jigsaw puzzles and then non-intentionally going up to bed. But regardless of my opinion on that, right, I have tried to be very fair about constitutional rights and everything else. But then when I got to my letter reading about, you know, how YouTubers are taking advantage the letters and like it's to the whole wide world and she's the main component in her case. I just can't stop laughing at her, Scott. Honestly, she amuses me. I'm not a fan. She amuses me though with the audacity. Then let's just say that.
Yeah, there's a bit of that. There's a bit of that. We have a special request, Welsh Lady, from Matthew Harris.
Go on.
He says,
from Matthew Harris. Oh, the lawyer.
Yes. He says, can we please get Welsh Lady Reads to record a soundbite that says, okay, chat, let's be nice now.
Okay. You want me to say that? Okay, chat, let's be nice now.
Okay, can you say it in a more motherly voice?
Okay, chat, let's be nice now.
There you go. We got it. All right, thank you so much.
That's what I say to my dog. Okay, now, Poppy, I'm calling. Let's be nice now. My daughter's 21 now. I can't really talk to her like that.
You can, but she doesn't listen.
Yes, she won't listen. She'll be like, what are you on about, Mom? And as my favourite Greener's going, is he all right in there?
Greeners has won the internet 4 days in a row. You know that?
4 days in a row. Oh, he's up to something, and he's fixing that for himself, I reckon.
I agree.
Yeah. Yeah. But are you well, Scott?
I am doing so well.
And Mrs. R.A.?
Better than I deserve. Really.
Mrs. R.A., she good?
She is better than me. So, yeah, we're doing well.
She's your better off.
Yes, she is.
Well, that's brilliant. I'm so pleased. I haven't spoken to you for so long, and I pop in, and sometimes I'm not chatting, but I always watch you, whether I catch you on replay crew, or whether I'm behind, but I'm just lurking, or I can pop in for a little bit.
It's wonderful when you do.
I'm always where my roots are, see? You are where my roots are. This chat was my beginning, and I love them all. There's some very dear people in there that mean a lot to me.
So I need to jump over to your channel on YouTube and see the latest and greatest. You've read some amazing things. We love your accent. So Welsh Lady Reads on YouTube. Welsh Lady Reads. Looking forward to
some things that might be a bit different to your channel, mind as well. So let's say.
Are you saying naughty?
Yes, just adulty. But
adultery or adulty?
They've all been adulty, as in adulty.
Okay.
But they are requests from chat. So I blame chat for it all.
Don't give in to that. They will ask for things that you just should not do. So you have to be careful. Welsh Lady, thank you so much for the call.
Oh, I've missed speaking with you. Thank you for taking my call. You take care of yourself now. Love all to you, chat, and love to Mrs. Ari as well, Scott.
Thank you.
Do take care.
Will do. You
Ta-ra,
too.
lovely.
Ta-ta.
Ta-ra.
Cheers. Oh my goodness, Welsh Lady Reads on YouTube. If you don't follow her channel and you like that accent, now you know where to go. We did. Josh Hutchins sent us a quick link for Judge Brantley Clark Bay County felony trial that just started with a pro se defendant. Before we do that, let me read a couple messages that I fell behind on. First of all, let's see. Lego My Brief says. Let's see, I don't know where I left off. Oh, my goodness. I think it was Golden Girl, happy Friday, 16 months. Thank you, Golden Girl. Kayla Newell, member for 9 months. I'm a full-term addict. We got that one. Weather Watch, best chat on the webs. Weather Watch, that's because we have the best mods. Ohio Jen, member for 17 months. Happy Friday, the best channel. Lego My Brief says, missed you. What, if anything, you've been up to? I think I read that one as well. Your double coverage is okay. Britta Aller, member for 13 months. Feel like an OG. Can't believe it's been another fantastic month with friends. What a wonderful place to watch true crime. John says, free Sarah Boone. We read that one as well. Joyful, member for 7 months. With the waving. Kyler. Carler. No, I read this one too. Thanks for the membership last night. Replay. It's a replay. Let's see. We had Megan Easton, member for 13 months, says no. Oh, it's not on the screen. There we go. Says, no prank call, no wrench, no mod chat, but still a great birthday. Thanks for celebrating with me. You all are so loved. Thank you very much, Megan. Congratulations on 13 months. Charlie Raven, member for 7 months, has been here longer, since Cavalcante, but celebrating today anyway. Bradley McKay, member for 8 months. I have to squint, use my good eye. Says, whoop, whoop. Good morning, everyone. We say howdy here. Welcome back to the gallery, the Orange Courthouse. Thanks for your over a year of support. KBF, we female attorneys always get dumped on like this, like Sarah Boone was doing. Mandy Strong says, in my opinion, Sarah is causing international delays. She now wants her attorney to focus on a bond hearing. Oh, I said international. It says intentional. Intentional delays. She now wants her attorney to focus on a bond hearing rather than her trial. Greeners says, thank you, Welsh Lady Reads, for the sunshine. Thank you, Greeners, as well. Great job with the internet today so far. Kim R., Welsh Lady Reads, we love you. Iris, a member for 5 months, says, ooh, right. I have a free one. Missed you all over Daybell time. Welcome back, Iris. And Annie Marie, member for 12 months, says, I've been here for more than 12, but who's counting? And Lenova, is today the day? Is Bitcoin going to go over 72,000 today? Thanks for the birthday cake. Appreciate that. Love the super sticker. All right, we are now. Let's see, where are we at? We're gonna jump to this trial and get a little bit of not soft sit, but pro se spice. I think it is. Let me back up just a tiny bit. What is that buzzing sound? Do you guys hear that? I don't know what it is. Okay. Either way, here we go. Let's go to, let's see, we're going to be on camera 3. Here's our judge.
And so do we have all the jurors here? Yes, sir.
Oh, it's a jury trial.
230, 229. Give me an update on
Okay.
Jen
Devka.
On the amended information.
4 months.
Amphetamine, 14 grams or more in possession of cocaine. Mr. Beecham, I need to ask you one question. There's a instruction, Mr. Beecham. There's an instruction in the preliminary instructions about a defendant having the absolute right to remain silent. Do you wish me to give that instruction during the preliminary instructions? And I'll read the instruction to you. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Do you wish to have that given this morning? No. That's just your right to remain. You don't have to have it, but if you decide not, it's up to you. It's a instruction that is given to the jurors to make sure they understand you don't have to testify. Okay. Sure.
It's not about actual cross-examination.
No, it's about you as a defendant, not you as not as you representing yourself, sir. It does not prohibit you from representing yourself or asking any questions. It's just to give the jury the information that you do not have to, that you're not required to testify, and they're not to consider that.
I think he had some chew in his mouth and he just took it out. I think so. That's what he just did.
Remember, Mr. Beecham, at any point in time you'd like an attorney, one can be appointed to represent you.
Oh, at any point, he leaves the option open. That's nice of him. Jan Devka, 4 months. Love it here. Thank you very much. Matthew Harris, howdy, chat. Good to have you here. Welcome.
See, we have Mr. James in the back slumming around here like he used to. Good to see you.
Stand by, attorney.
It's good to come around here just to remind my roots back before
I thought you were going to say remind you how good you have it now.
Yeah.
Didn't hurt my feelings.
This is a cocaine possession trial, pro se defendant with a jury. We're just waiting for the jury to come up. This is happening today. We're just a couple minutes behind.
I appreciate your help this morning too. Thank you.
This is the 14th Judicial Court of Florida.
Make it up this weekend.
Florida.
Yeah. I hope so. Yeah, I know we went last weekend.
Judge sounds like he's from Texas. They're in Florida. We're trying to cover Wade Wilson. Starts on Monday.
Give me 1 second and I'll be ready to bring them in. Okay, just let me know when they're all out. Sure.
We've popped in this guy's court before. I seem to like him, if I remember correctly. Might fast forward just a little bit as we've see how far back we are. A few minutes, about half an hour maybe. Let's see what we got. Jumping ahead. Okay, are we ready, Judge? Oh no, JM, you sent your chat sticker 12 months, but I never read it. I am so sorry. JM, congratulations on 12 months. Love the profile picture, by the way. What a happy couple. Congratulations. Thank you for 12 months of support. Would not have been the same without you here, JM. Appreciate that. It's not hear ye, it's yee-haw. Iris, that is hilarious.
Are we ready to bring them in?
Yeah, we're ready to Jurors. Go ahead and bring them in.
Jurors in.
Jurors come in from the back door. Here they go. Get to watch them.
Come on board.
Welcome, Icy. Thanks for always doing your best. The best job fixing court audio at 6-7. It's deeply appreciated. The one thing I can't do is turn on closed captioning. It often causes problems.
Jurors, if you'll remain standing just for a second, everyone else in the courtroom, you can have a seat. Madam Clerk, you swear the jurors?
Will you all raise your right hand, please? You do solemnly swear that you will well and truly try the issues between the state of Florida and the defendant, whom you shall have in charge, and a true verdict rendered according to the law and the evidence. Thank you.
Good morning, have a seat. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Josiah Marquise Beecham. This is a criminal case. Beecham is charged with 2 counts, trafficking of methamphetamine, 14 grams or more, and possession of cocaine. The definition of the crimes charged will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Mr. Beecham in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Mr. Beecham has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, Mr. Sullivan and Mr. Beecham will have an opportunity, if they wish, to make an opening statement. The opening statement gives Mr. Sullivan and Mr. Beecham a chance to tell you what evidence they believe will be presented during the trial. What they say is not evidence, and you are not considered as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyer, or the argument of Mr. Sullivan and Mr. Beecham, and the instruction on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no email, text message, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify the bailiff of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you in your presence about this case, tell him or her that you're on the jury trying the case, and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recess, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, smartwatches, or any other electronic devices. If someone needs to contact you in an emergency, the court will receive messages and deliver them to you without delay. The case must be tried by you only on the evidence presented during the trial and in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're at the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided a notepad and pen for use if you wish to take notes. Any notes that you take will be for your own personal use. However, you should not take them with you from the courtroom. During recess, the bailiff will take possession of your notes and will return them to you when we reconvene. After you've completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence and should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any message related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on the internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that will require the entire trial process to start over. And a mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayer. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Mr. Sullivan, Mr. Beecham understand the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it's made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it will be necessary to confer with Mr. Sullivan and Mr. Beecham out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. Mr. Sullivan, whenever you're ready. Thank you, Your Honor. You may call your first witness. I'm sorry, take your oath in a second.
Thank you. November 11th, 2023, this defendant, Josiah Beecham, was found by Officer Richard Ziff of the Panama City Police Department to be in possession of a trafficking amount of methamphetamine as well as a quantity of cocaine. You're going to hear from Officer Richard Ziff today. He's going to tell you that on November 11th, 2023, the defendant was driving along Beach Drive, not far from here, when the officer conducted a traffic stop on the vehicle that the defendant was driving. He made contact with the defendant, and during the course of this traffic stop, ultimately ended up searching the car. When he searched the car, he also searched Mr. Beecham's person, and he's going to tell you what he found. He's going to tell you that in the back seat, just behind the driver's seat, within reach of the driver, was Mr. Beecham. He found a couple containers. In one container, there were several white powdery substances in baggies. In another container, there was another similar powder in baggies. And there were these pill-like substances that were ultimately sent to the Florida Department of Law Enforcement and determined to be methamphetamine. What you're going to hear is that the one substance in one of those containers was sent to the Florida Department of Law Enforcement, tested positive for cocaine. And you're going to hear from the analyst today. His name is Sam Catalani. He's going to tell you about that. He's going to tell you that not only did he find that these substances were methamphetamine and cocaine, but the methamphetamine in this case actually weighed 15 grams, which is above the threshold for trafficking that we talked about on Monday, which was 14 grams. You're also going to hear from Officer Richard Ziff that the one container that held the multiple baggies of the white powder that was found with the cocaine and the methamphetamine, the officer, when he searched Mr. Beecham's person in his front right pocket, he found the exact same baggie, the exact same powder in that as well. Mr. Beecham told you Monday during jury selection when we talked about possession that there's a knowledge element. And he's correct, there is. In this particular case, the evidence that you will have that Mr. Beecham had knowledge of the substances in the back seat is because he had that exact same thing in his pocket as well. And you're going to hear that from Officer Ziff. This is not going to take all day. This is not a complex case. It's pretty simple. Those are the two witnesses I expect you to hear from today. And then after you hear all the evidence, the judge will give you the law. He'll read you the instructions and tell you what I have to prove beyond a reasonable doubt for you to find the defendant guilty. And what he's going to tell you is that for the first count, trafficking in methamphetamine, I have to prove three things beyond a reasonable doubt. The first is that the defendant knowingly possessed a substance. The second thing is that that substance was methamphetamine. And the third thing is that the methamphetamine weighed more than 14 grams. For count two, the possession of cocaine, I have to prove two things beyond a reasonable doubt. The defendant knowingly possessed a substance, that substance was cocaine. After you've heard all the evidence in this case, there won't be any reasonable doubt that the defendant's guilty of these charges. And at that time, I'm going to come back before you. I'm going to ask you to find the defendant guilty as charged. Thank you.
Mr. Beecham.
Excuse my time, ladies and gentlemen. I wasn't able to make bail, couldn't afford it. Ladies and gentlemen of the jury today, you merely heard the related allegations from the prosecutor. And as he said, it's not my duty to prove my innocence, but the state's duty to prove my guilt beyond a reasonable doubt by meeting every element of the case. And the elements of this case, like he said, is to have the knowledge and the dominion and control over the drugs. You will hear allegations also as well from the police officer. As y'all heard Your Honor speak today, we're in the age of technology. And there's plenty of technology exists, such as body-worn cameras that the police have. that the police actually had on him. And the body worn cameras, along with the actual evidence that was presented, does not prove me guilty of anything. It actually proved my innocence. The officer in this case, as the state already knows and admitted, did commit false statements.
Objection, Your Honor.
Thank you.
And
bold move.
well, yeah, the officer in this case is going to make allegations that can't be proved beyond a reasonable doubt. And a camera would easily prove anything to anybody to show what happened. But as far as an allegation, as well as a charging document and submitted evidence, would actually prove the allegations better. And so today you're going to see evidence probably presented from the state, and the witnesses will come in to testify. And I want to give you, I'll let you guys see a copy of or hear the testimony of the state and the witnesses, but actual documented evidence that was documented into evidence, you'll see I actually had no drugs on me, as well as the video footage. There was no drugs on me, so the officer just, made that statement up.
Made that statement up.
Out of multiple officers that were on the scene, but only one's coming. So that'll be all for today right now, and I thank you guys for coming over here today.
Mr. Sullivan, you may call your first witness. Sergeant State Calls Richard Ziff.
First officer on the stand.
I do.
You can have a seat, speaking to the microphone, and Mr. Sullivan, you may inquire whenever you're ready.
Thank you, Your Honor. Morning, sir.
Morning.
Can you please introduce yourself to the jury?
Officer Richard Ziff, Panama City PD.
How long have you worked for the Panama City Police Department?
2 years.
And where did you work previously to that?
Garfield County Sheriff's Office in Colorado and El Paso County Sheriff's Office in Colorado.
And how long were you a law enforcement officer in Colorado?
It was all law enforcement from 2013 to 2022 in Colorado.
I want to take you to, well, before we get to that, what are your general duties with Panama City Police Department? What do you do?
I patrol the city, respond to calls for service. I'm drive around, be proactive, prevent crimes, deter crimes, make arrests, interact with the citizens of Panama City.
As part of your job duties, do you routinely do traffic stops and things of that nature?
I do.
We'll take you to November 11th of 2023. Did you conduct a traffic stop on that date?
I did.
Where was that traffic stop? Where was that located at?
It was going to ended up on Fairland Avenue and West Beach Drive.
And what was the basis for conducting that traffic stop?
When I turned on to West Beach Drive from Balboa, I witnessed a vehicle in front of me that was having a hard time maintaining its lane. Eventually, the vehicle started drifting over the traffic control device, which is the center median solid lines. So at that point, I activated my overhead blue lights to initiate the traffic stop on the vehicle, with the vehicle coming to a stop on West Beach Drive and Fairland Avenue. While it was, when it came to a stop, it actually drove over the curb.
When you say the center median traffic control device, you're talking about the yellow lines?
Yes.
Ultimately, when you conducted the traffic stop, did you make contact with the driver?
I did.
Were you able to determine who the driver was?
It was Mr. Josiah Beecham.
Do you see that person in the courtroom today?
I do.
Yeah. Identify him.
He's to my right.
Let the record reflect that he said the witness has identified the defendant.
The record will so reflect.
When you made contact with Mr. Beecham, did you do your standard license registration, all that kind of stuff?
I introduced myself as Officer Zip, MLC PD, told him the nature for the stop, which is because he was having a hard time maintaining his lane, and immediately told him as well that I detected the odor of marijuana coming from within the vehicle.
Ultimately, as a result of this traffic stop, did you end up searching the vehicle?
I did, because I developed probable cause to search it after I had plain smell of marijuana.
Did you also ultimately end up searching Mr. Beecham's person himself?
I did.
I want to talk a little bit about what you found. If you could look, there should be a couple photographs in a little folder for me. I apologize, they're not there. May I approach, Your Honor?
You may approach.
I'm showing you what's been pre-marked for identification of State's Exhibit 1A, B, and C. If you could take a look at those 3 photographs, please. Those photographs accurately depict what you found when you searched the vehicle and Mr. Beecham's person.
Yes.
All right, this time the state moves State's Exhibit 1A as an alpha through 1C as in Charlie into evidence.
Any objection?
Object, Your Honor. No more evidence, that's all my submission.
I'll overrule that objection. States A. Is that the objection? There was other exhibits? Mr. Beecham?
Yes, Your Honor, that wasn't actually submitted in the evidence.
Okay. I'll overrule the objection based on that and states A. What was that? States A1 through?
A through.
It wasn't
1A through C.
1A through C. You may publish.
I'm gonna have to hide so you can see.
Officer Zip, I want to talk about State's 1A here. We've got a couple of different things in this photograph. We've got these 2 containers in the front, and then we've got a bag of some pill stuff in the back. First off, were all of these 3 items located in the same place?
No. 1A and 1C were located in the bag behind the driver's seat. And then
I get what you're saying. I want to talk about just 1A.
Oh, yeah.
The three items that are in this particular photograph in 1A.
Yes.
Were they all located in the same place?
Yes.
And where were they located at?
They were in a bag located behind the driver's seat.
I want to talk about the item, the container on the left in this photograph. Was that item collected?
Yes.
Was it ultimately submitted into evidence?
Yes.
And was it sent to the Florida Department of Law Enforcement?
Yes.
May I approach, Your Honor?
You may approach.
I'm showing you what's been pre-marked for identification of State's Exhibit 2. Do you recognize this?
Yes.
Is this State's Exhibit 2 the contents of the container on the left in photograph 1A?
Yes.
Your Honor, this time the state would move State's 2 into evidence.
Any objection?
What's the officer reading?
Jake, what is it?
You'll show Mr. Beecham, please.
I object. What is that? He's looking it over. These don't look like drugs.
What is it?
The container on the left.
Beecham, anything else? Or now accept State's Exhibit 2 into evidence. You may publish whenever you're ready.
Thank you, Don. I want to talk about the item at the top in photograph 1A, top of the photograph. And I'm going to skip to 1C real quick. Is this baggie the same item that was in the top of the photograph in 1A?
Yes.
Was this also collected and sent to the Florida Department of Law Enforcement?
Yes.
May I approach, Your Honor?
May approach.
So they bring
You recognize this?
Yes.
I'm showing you what's been marked for identification in State's Exhibit 3. State's Exhibit 3, is that the items that are depicted in State's photograph 1C?
Yes.
They're handed the
And
defendant.
that was taken from the same baggie as, or the same bag in the back seat as the item that was collected in State's Exhibit 2.
Yes.
Your Honor, this time the state would remove State's Exhibit 3 in evidence.
Any objection?
I see what it is.
Yes, sir. Mr. Sullivan, you're short. Mr. Beecham, please.
So they're going to hand the defendant the drugs right now. How I don't see this going poorly at all.
Or any objection?
No, sir.
All right, State's Exhibit 3 will be accepted into evidence. You may publish whenever you're ready, Mr. Sullivan.
Now, I want to go back to when I talked about the container on the right. What was contained in the container on the right? Can you describe the substance, what it looked like, and how it was packaged?
It was a white powdery substance that was packaged in a clear plastic baggies, individually wrapped.
Were there multiple individually wrapped baggies?
Yes.
And that was found in the bag in the back seat along with State's Exhibit 2 and 3.
Yes.
I want to talk about the photograph States 1B is in Bravo. What are we looking at here?
It's another bag that was located in Mr. Beecham's right front pocket when I was doing a probable cause search of his person.
So the item in this photograph was actually taken from Mr. Beecham's pocket.
Yes.
What's the objection?
The evidence is not proved.
He's just asking a question now, so I overruled the objection. You can make another objection if there's any introduction.
So this photograph, this item was actually taken from Mr. Beecham's pocket.
Yes, it was found in his right front pant pocket.
And the substance and the packaging of this item, was it identical to the substance and items in the container on the right in States 1A?
Yes.
Here's a question. Was everything weighed
Now,
in
I
the
want to talk to you a little bit
baggies?
about, were you wearing a body camera when all of this happened?
I was.
And was your body camera on at some point in time?
Yes.
At some point in time, did your body camera get turned off?
It did when I pulled him out of the vehicle. His elbow hit my body cam and deactivated it.
When you pulled him out of the vehicle, and attempted to put him in handcuffs and detain him, correct?
Yes.
Was Mr. Beecham cooperative in that process, I guess?
No.
Did he struggle a little bit?
Yes.
And during that struggle, is that when your body camera got turned off?
Yes.
At some point in time, did you realize your body camera was on or it was off and turn it back on?
Yes. The moment I realized it was off, I immediately turned it back on and informed my supervisor that body cam got turned off.
And by the time that you had realized it and turned it back on, had you already begun searching?
Yes.
Had you already found the items that we've already talked about?
Yes.
So your body camera footage doesn't actually capture you searching the vehicle or searching Mr. Beecham?
Unfortunately, no.
Your Honor, I've got no further questions at this time.
Mr. Beecham. Sit there at your desk, or you can go to the podium wherever you feel comfortable.
So, made the traffic stop, and when you made this traffic stop and approached the vehicle, how many occupants was in the vehicle?
It was you and Mr. Wheeler.
2 occupants.
Yes.
Did I challenge you in any manner or ask for any, challenge the reason why you stopped?
You challenged me as far as why I stopped you, my authority to stop you, and you immediately wanted me to have Bay County Sheriff's Office arrive on scene because you did not want to speak with me. You also stated that I was violating the treaty between you and the state of Florida several times.
So I asked you to call the sheriff, right?
Yes.
And then after you said this is not the sheriff's jurisdiction, then I also asked you to call your supervisor.
Yes.
Okay. And
it's a treaty with the state of
calling
Florida.
back up is a safe concern for multiple individuals, and it's easier for more officers to contain and see more people, right?
Right.
All right. At a preliminary hearing, you testified as well.
Objection, Your Honor, proper impeachment.
Sustained.
I'm not talking about the false allegations, Your Honor.
I have to rephrase your question.
He's got something. He's got a prior testimony.
Point
that
when you
might
removed me
conflict.
from the vehicle, did you have eyes on the passenger?
I lost eyes on him because I had to focus on you, and my officer safety involved me having to safely remove you from the vehicle.
The drugs were allegedly found in what type of?
A clear plastic baggie that was located in a backpack behind your seat.
Is that a brown bag?
No, they were in a clear, each of them were wrapped in clear plastic baggies in a backpack behind the driver's seat.
Well, in your narrative.
Objection, Your Honor, improper
impeachment.
Sustained. It's improper impeachment. You have to rephrase your question.
Okay, did you ever testify that they were in a brown bag, or write in your narrative that they were in a brown bag?
It stated they were in a bag.
He got the question in. He's got notes. He's got a plan. He's been studying.
Can I approach you?
Yes, you may approach.
Is this your narrative report?
Yes.
Could you read the top of that for me?
A brown paper bag.
Thank you. So did you write this?
Yes.
Does it help you remember?
That means my report.
So they were in a brown bag?
The brown bag was located in the bag behind the driver's seat.
And the containers in the picture, you want to see this? You already have a copy.
He already got a copy.
And
so there's a bag in a bag.
all the collected items were seized and documented in the evidence, right?
Yes.
The prosecutor doesn't even want to look at it.
That's not the bag, so.
So you said cocaine?
Yeah.
Yeah, cocaine's right there.
That's not the bag, right? I don't say the bag, the one that's in this exhibit. Eight. Where is it?
I'm not losing difference.
So apparently there was an outer plastic bag and an inner brown bag.
What I've grouped into evidence is sitting right up there.
And the evidence that you submitted, what all was found in that brown bag? Would you relate that to the court?
There was the two items in front of me, and then there was bags individually wrapped that contained a green leafy substance that had the odor, distinct odor of marijuana. And it was individually wrapped as well.
Oh no.
Was that all that was found?
There was these items and the white powdery substance as well. There's also the oxy.
Oxycodone?
Yes.
He's like, it's
what was how many bags were there?
Per the evidence sheet, there shows to be
Mr. Beecham, you need to back up just a little bit, okay?
one that was entered for 5, and then one was entered for 8.
So it's 2 separate bags?
Yes.
And what about the cocaine?
Shows here that the cocaine was entered all together in one submission.
All together in one submission?
Yes.
It's, actually, if you look at it, it's
Yes.
2 different.
So the way we did it was we entered all the cocaine together, got a total weight of all the cocaine. There's not any record of how many bags there were. It's just a record of how much the total weight was of the cocaine. That's how we determine the charge amount, is if it's going to be based on what the weight is.
So one item is something different from something else. You know, say cocaine here and cocaine here.
One's crack, one's cocaine.
What's the objection?
I think it's improper to questioning that. I don't know what he's getting at.
I just object generally. K-Rab, thank you very much. Special kind of sob sit called a Moore. They They believe that's where the treaty comes in. They believe they're aboriginal to the U.S.
I withdraw my objection.
All right. Mr. Beecham, you can continue.
Sharon, thank you very much. 16 months.
So you put all the
Great
drugs
mod.
together.
Thank you.
All the drugs are all similar. So you got two different types of the white powdery substance. You got the one that was on my right here, which is a more chalky white. And you got the white powdery, which is going to be the other stuff that was found in your pocket as well in that bag.
Okay, and you say you submitted all the stuff together. What stuff you put together?
All the stuff that was powdery, you put that as well as the marijuana. It's all gets put together to get a total weight.
Okay, well, the evidence don't reflect that with the oxys. That didn't go together.
Because that's not based on the weight. That's going to be based on the
The objection
residual
is
amount.
sustained, officer.
He's objecting to
So
the
there's
weight.
nothing logged here saying that it came out of my pocket.
That's just an evidence sheet.
Okay. Now, all the evidence you guys collected, you said your body camera wasn't on when you found any of it.
No, because your elbow hit me on my body cam. Deactivated my body cam.
Could you demonstrate that to the court? Do you have your camera on you today?
Yes, my body cam's on me right now.
How does you actually activate it? How does it turn on and off?
When the body cam is actually on, for the purpose of being in court, my body cam's off right now. So on my body cam, there's a button right here in the front that my index finger is touching right now. When I push that, that activates my body cam. Push it again, it turns off the body cam.
They need to
So
change
when
that
I
feature.
initiated the stop, immediately my body cam turned on. When Mr. Beecham refused to come out of the car, I had to remove him from the car, and because he was not cooperative with me, I swung him around the car to put him against it to control him. His left elbow went into my body cam button, deactivating my body cam.
They need to have like a triple tap to turn off. So it's got to be intentional.
It's like pushing the button that deactivates.
Based on the amount of pressure, yes. Like I said, I had to push you against the car to control you because you were not cooperative.
And all these items were they analyzed for fingerprints. I see a container here. It was a brown paper bag. Were they analyzed for fingerprints? And did the fingerprints come back as mine?
I do not know FDLE did with the containers. All I know is that the items were in your control. They were within your reach.
They were in my control and in my reach.
Yes.
You said they were behind the seat on the floor.
No, they were behind your driver's seat in the passenger seat.
They were
Behind, so the back seat on the driver's side is where the items were located.
okay on the floor.
But then your car was a mess. It was behind the driver's seat.
Okay, so it was a lot of stuff in the car.
You had a lot of stuff in the car.
Okay, and you said my car. Was that actually my car?
It was your girlfriend's car.
It was a girl car.
Your girlfriend, she showed up on scene, told us that she was your girlfriend. You even told us on scene that it was your girlfriend.
Okay, just making sure.
Just
It wasn't
making
my
sure.
actual car.
That's the next one.
I'll have an answer to the question. Let's move on.
And you said you lost sight of the passenger. And you didn't get these items analyzed for any fingerprints to prove that they were actually mine?
No.
You said you mixed all the substances together.
All the substances that were all the same, such as the white powdery substance that I field tested on scene as cocaine, were yes, put together, as well as the crack cocaine and the oxycodone, which was identified via pill finder.
Okay. So mixing drugs together, is that proper policing or keeping them separate to clearly identify what they are as far as the FDLE report?
Our policies have us placing all the drugs that tested positive the same, putting it all together so we can get a total weight of the drugs. We cannot get a proper weight if we keep them in the small baggies because it ends up adding weight to it. So your baggies were all put into a separate evidence for paraphernalia.
So a field test kit to prove what the drug is, and you said you field tested the pills here as well. What did they field tests come back as?
I don't need to field test the pills. The pills had identifying or numbers on them. The oxycodone.
No, not those, the colorful ones that's in the exhibit.
Oh, these ones? The exhibit number 3?
Yes.
So those tested positive for fentanyl, but the lab came back as meth.
So the field test is not always accurate, right?
Not always, but these items did come back from FDLE.
Okay, exactly. And so that's why I don't think it's proper police work to mix the drugs. That's called co-mingling.
If you want to change our policies, you can come to the Plano City Police Department.
You just answer the question instead of giving a narrative.
It's our policy.
It's the policy to mix the drugs on the scene.
That's the answer, Your Honor.
Staying, move on.
Yes, sir. And okay, the original charging sheet that I have, did you submit those charges?
I did.
Do you remember what I was actually charged with?
Objection, relevance.
Staying.
Did you tell the court what I was charged with today?
Objection, relevance.
Staying.
Relevance is so they can know what I was originally charged.
Y'all approach.
Okay.
Well, how's it going? Bailiff gets right up there with the judge. First sidebar, I guess that's an accomplishment as a pro se defendant to make it all the way to the sidebar. At least then you get to make an argument directly to the judge, which doesn't have to be. I think you can get different wording in an argument with the judge as a pro se defendant. I don't think it's going well for him. Here's what's happened. We had a little bit of testimony about meth and cocaine. And then the defendant got up and started asking questions, and now we're hearing about marijuana, we're hearing about fentanyl, we're hearing about other things that the state did not bring in with this witness. I think it would be better for him, first of all, get a lawyer. I realize it's your right. That's awesome. Get a lawyer. It would be better for him to focus on the body cam. Introduce doubt as to the narrative that the officer has presented. The officer says, "Oh, there was a struggle and your elbow hit the button." I want to see the video up until I want to hear that impact. I want to see my arm coming back towards the body cam. If it's there, you're toast, right? But if it's not, and you're away from the car and he's several steps away from you and suddenly his body cam turns off, that might look like the officer intentionally turned off his body cam to plant drugs. That's what he would try to do. There's some reasonable doubt, right? No fingerprints, not his car, no body cam. It's his girlfriend's car. Girlfriend showed up. We have not heard, other than the officer, anything about the treaty he has with the United States has been violated. But see how this goes. He's not doing too bad. What impressed me is when there was an objection sustained to the form of the question that he was asking. The judge told him, due to the form of the question, I sustain it, and he was able to revise the question and get to the answer he wanted. That takes skill. That takes some skill. A lot of times, it's very difficult for a pro se defendant to do that because they're focused on the injustice they perceive that they're the recipient of, and they just want to blurt it out. This is the problem, and instead of looking at the mechanism the court uses to allow evidence and the ask and answers, the proper procedure, they just go for the gold and end up not laying the foundation that could have gotten them there had they gone to law school and learned a little bit about proper questions, leading questions, which they can do on on cross. But We'll see how well this works. He could have foiled. It's going to be provided. The body cam's got to be provided with Discovery. He's got all that, I'm sure. And if the body cam is not good for him, he's not going to want to show it. But the state will. He could have hung out and chat a little while and learned a few things from y'all. He's objecting to the policy, which the officer got a little snarky with and got sort of smacked down by the judge. But the officer got a little snarky with the policy. The policy is that when you make a drug stop and there are multiple substances, they test all the substances there together. And the substances that come back with the same results, even if they're bagged separately, they're put together because the law is written that if you have a certain amount of a certain substance, if it's under, say, the threshold in this case was 14 grams or less, that would be considered personal consumption. If it's over 15 grams, that's going to be distribution. Distribution carries a heavier penalty than personal consumption. It might be possible to get distribution charges just from paraphernalia, depending on how the law is worded. If you have, scales and, lots of little baggies and all the other stuff you would have if you had a lot of drugs to distribute and sell. And in this case, he had a lot of the little baggies. They was all pre-bagged. They were in distribution amounts. And when it added up together, it was enough to be 1 gram over that personal consumption. So he had 15 grams, barely over the limit. Ashley, that's our plan. Yes, for those that are coming in, we did follow the Sarah Boone hearing this morning. It was brief. It was spicy. Sarah Boone had a verbal exchange with the judge, complaining about her lawyer, not happy with the lawyer's attitude, not happy with the lawyer's work, not happy with pretty much all the same things we've heard before as well. Believes the lawyers lied to her. The judge probed some of those issues and I think was satisfied based on the answers that he received that the lawyer really hasn't lied or done anything wrong. It's just Sarah Boone doesn't like having a lawyer that's just trying to give the best defense possible. Instead, she wants a lawyer that will coddle her, encourage her, agree with her, even on her narrative. And so far, she hasn't found one that does that. So Sarah Boone, she also wants a bond. She's requested a bond. The lawyer supposedly is stalling or preventing that from happening. There may be a hearing on the bond. That might happen. That might go forward. But I doubt the bond would be extremely low. She does have a fairly good argument that she's been held in jail for a long time without a hearing, which would be in her favor for sure. And although she doesn't have any money to pay that bond, she says that her fans would probably put together a GoFundMe and she would be able to reach that. So that's the update on Sarah Boone. 10/7 is the court date. There'll be a hearing on 9/24 for trial management.
Have you ready, Mr. Beach?
So, you said none of those stuff was analyzed for fingerprints?
No.
Assume the stuff was mine because
It was in your control. And then, like I said, you had a clear plastic baggie of the white powdery substance, which matched the same substance that was found in the bag behind the back seat, or behind the driver's seat in the back seat.
and the body count is not on.
Objection, ask the answer.
I overrule the objection. You can ask it again.
All right.
It was overruled.
If you were to say
and he didn't ask it.
Exhibit A and Exhibit B said that you say you mixed that all with the stuff that was in Exhibit A.
In the right container, yes.
So why is the pictures still separate?
Because we take pictures of all the evidence we have for this type of purpose, and then we mix it together, get a total weight.
should only have 2 witnesses today.
That'll be all right now, y'all.
Can you read her at?
Yes, Your Honor, may I approach?
You may approach.
Officer Zip, I'm going to show you what's been marked for identification purposes as State's Exhibit 4, 5, 6, and 7. So earlier when you were testifying, I asked you about some of the items that you found in the vehicle. And we talked about the suspected cocaine in the container on the left, suspected cocaine in the container on the right, and the suspected methamphetamine. There were those multicolored pill type things, correct?
Yes.
Okay. Mr. Beecham asked you some questions about some other items you found. I'm showing you what's been marked for identification in State's Exhibit 5 and 6.
Yes.
Do you recognize those?
Yes, that's the oxycodone.
These are the oxycodone pills that you found in the same location.
Yes.
These were not tested by FDA, correct?
I do not believe they were.
I'm showing you what has been marked for identification in State's Exhibit 7. Do you recognize that?
Yes.
What is that?
It's the green leafy substance that I identify as marijuana based on the distinct odor.
And this was also found the same location?
Yes.
And this was not tested by FDA, correct?
No.
I'm showing you what's been marked for identification in State's Exhibit 4. You recognize this?
Yes.
What is this?
That's going to be the white powdery substance that's going to be in 1A on the right, as well as the white powdery substance that was in his pocket.
Madam Clerk, if I could have the screens again, please. Yeah. So I want to clarify this a little bit. I want to clarify your testimony about mixing things together.
Yes.
So the items, let's start with 1C. That baggie, when you took this photograph in 1C, this photograph was taken as the items were found, correct?
Yes.
So they were not mixed together in this baggie by you.
No, they were all, it was found just like that.
And this baggie, this photograph again was taken to document the item as it was found in Mr. Beecham's pocket.
Yes.
So this baggie, nothing was added to it or taken from it prior to this photograph.
No.
In these photographs, in these 2 containers, this photograph was taken as the items were found.
Yes.
To document the condition that you found in them.
Yes.
Nothing was added to either one of these containers or taken from either one of these containers.
No, the containers are exactly found. The picture were taken exactly the way they were found.
Now, when you talked about what you mixed together and added together, we're talking about the clear plastic, the powder in the clear plastic baggies in the container on the right.
Yes.
Along with this baggie, correct?
Yes.
Those baggies were mixed together because they were all the same white powder.
Yes.
And that's what's in State's Exhibit 4, correct?
Yes.
I was talking State's Exhibit 4 and evidence.
Any objection?
Yes, I object, Your Honor, because officer did say that field test is not an accurate test. It actually also tested fentanyl, positive for fentanyl for the pills. And that substance is not proven to be a separate substance that was actually found.
State's Exhibit 4, is that the whatever the contraband was found in the Mr. Beecham's, was allegedly found in Mr. Beecham's pocket and in the back of the seat?
Yes, Your Honor.
So what I'm going to do is I'm going to sustain the objection at this time. I assume there's someone else that's going to testify as far as that substance. Is that correct?
May we approach, Your Honor?
Sure.
Sustain the objection. If these items don't get brought in, is it possible that the quantity gets lower than 15 grams? He got a good objection because the field test said fentanyl. They sent it to the lab. It said meth. Did I say fentanyl? Fentanyl. We are in Florida, by the way. I'd love to see the body cam footage on this. We'll see if it gets brought in or not. But so far, no dice. I think a lawyer could have gotten a little more mileage out of some of the circumstances of this particular case. And I think also the prosecution is worried that this is going to get thrown out. Just that portion, the whatever drugs that were tested as positive as fentanyl but came back as something else. See if the ruling's made back on camera. Oh, they're bringing more evidence over to the judge to talk about it. Judge is trying to get a grasp of what was found where and what was combined into what. I'm just surprised they handed all the drugs to the defendant, like the actual drugs, instead of just the pictures. I think there's one other officer who's going to testify, Angela. Just the two officers are all the state has. I don't see anybody here to testify for the defense. I doubt the girlfriend could testify. She showed up on the scene after the stop. Possible Mr. Wheeler, the other occupant of the vehicle, might be asked to testify. But you know he's not going to be like, oh yeah, those are mine. They weren't the defendants. Those are my drugs. That's not going to happen. Monica, it would look bad if he's shown fighting with the officer. Long sidebar. You know what we're going to do? We're going to jump ahead because we can. We're about 20 some odd minutes behind. Let's see. Where are we? So we're right here. There we go. Skipped a couple minutes.
What are you asking me in evidence?
Your Honor, it's on Exhibit 6, Exhibit 4 in evidence.
That'll be over objection. State's Exhibit 4 will be accepted in evidence.
Oh, sidebar. The defendant lost. Judge allowing it in.
I believe that's all the questions I have for the officer. Thank you.
Any other questions, Mr. Beecham?
Jury trial.
Okay.
Do you remember how much cash was alleged to be on the driver?
I do not.
How much cash?
Did any of your other fellow officers body camera was on?
After they showed on scene, yes.
Now he wants his money.
His drugs, you say, were all individually wrapped?
Yes.
Didn't submit anything for print?
No.
Is there a reason why not?
We generally do not submit for prints, especially when I can prove that was already in your control.
Could you explain that control?
was within your arm's reach. And on top of that, like I said, the bag that's on the camera or on the TV monitors was located in your pocket was the same substance that was found in one of those bags.
Okay, and how sure are you of that, saying that there's no evidence of that? So
I'm pretty sure.
Pretty sure.
100%.
100% sure.
Yes.
So how are you 100%? Explain that.
Like I said, it was within your arm's reach. You had the same items in your pocket that was in the bags.
Is it the same item or items?
The bag that was in your right front pocket of your pant pocket is the same bag, same type of item, same wrapped item that was in the baggies. It was in the bag in the back seat.
But you didn't keep it separate, and you don't have no footage of this bag being removed.
No, because you hit my body cam.
Well, that'll be all the questions.
Any other questions?
No, Your Honor.
Can the witness be excused?
No, I'd ask that you remain under subpoena.
Sir, you're still under subpoena. You can leave the courtroom, however, you may be recalled as a witness.
Yes, sir.
Mr. Sutherland, may call your next witness.
This time, State Fellow Sam Catalani.
Did he say he could remain in the courtroom? He's not staying in the courtroom. This is a version of a sob sit and mostly just pro se. I just didn't know if they're doing the exclusionary rule.
Come on forward.
Ooh, he's got the suit. Must be the lab tester guy.
And raise your right hand, clerk will get you sworn.
You solemnly swear or affirm that you're about to meet the truth, the whole truth, and nothing but the truth and nothing but the truth. Yes. Thank you.
You may have a seat. Mr. Sullivan, you may inquire whenever you're ready.
Good morning, sir. Hi. Can you please introduce yourself to the jury?
Sure. Hi, my name is Sam Catalani.
Hey,
Where are you
Sam.
employed?
I'm employed with the Florida Department of Law Enforcement.
What do you do for FBO?
I'm a crime laboratory analyst supervisor of the Seized Drugs Department.
What is the Seized Drugs Department? What do you guys do?
Basically, we analyze evidence for the presence or absence of controlled substances.
How long have you worked for FDLE in the Seized Drugs Department?
For almost 25 years.
What type of education, training, experience do you have that allows you to do your job?
I have a bachelor's of science majoring in biology. I've completed FDLE's training program of the seized drugs discipline, and I also undergo continuing education courses yearly.
In your 25 years with FDLE, how many times would you say you've had occasion to analyze a substance to determine whether it's a controlled substance or not?
Over 30,000.
Have you ever testified as an expert witness in court before?
Yes,
How many times?
approximately 400.
All right, it's time to state the tenure of the witness.
Beecham, any questions?
Did he say 400? New.
Based on Mr. Catalani's qualifications.
No.
All right, Mr. Catalani will be able to give his opinion. Mr. Sullivan, you may continue.
Mr. Catalani, were you asked to analyze items of evidence in this case?
Yes,
How many items were you asked to analyze?
there were 2 items submitted.
May I approach?
You may approach.
I'm going to show you what's been marked for identification in States Exhibit. What's been admitted into evidence in States Exhibit 2 and 3. They correspond with the FDLE issue, numbers 1 and 2. Okay. You take a look at those for me, please. Are those the 2 items that you were asked to analyze?
Yes, they are.
Can you tell the jury what you do as far as your analysis goes when you receive items like this?
For anything that's not a plant material, I typically weigh the material, and that's just the substance, not packaging or anything. So I get a weight, and then I perform 2 instrumental analyses.
And what is the purpose of doing those 2 instrumental analyses?
The two instrumental analyses are used for me to identify the material.
And did you do that with both of these substances?
Yes.
I want to talk about State's Exhibit 2. I believe that's FDLE item number 1. First, were you able to determine how much that substance weighed?
I was.
And what was the weight of that substance?
It was 11.29 grams.
And were you able to determine what that substance was?
Yes.
What was that substance?
I identified cocaine.
And State's Exhibit 3, that is FDLE item number 2. Were you able to weigh that substance?
Yes.
And what was the weight of that substance?
The total weight was 15.17 grams, plus or minus 0.20 grams.
And that 15 grams, I think you testified earlier, that is the weight of the substance alone and not any packaging that it's in. Correct?
Yes. Yes.
And were you able to determine what that 15 grams of substance was?
Yes.
And what was that substance?
I identified methamphetamine.
All right. The state has no further questions.
Mr. Beecham?
So you didn't get any powdery substance to test?
The only thing I have to test was this white chunky substance and some multicolored tablets.
Was it labeled where they came from? Like exactly? Police submission did it submit one? Actually. Not really.
It doesn't mention where it came from on the evidence.
I don't have any question.
All right, can the witness be excused?
Yes, Your Honor.
Or you may go about your day.
Thank you.
All right, this on the state rests.
All right, ladies and gentlemen, this is the appropriate time to take our morning break. We're going to take a 15-minute break. We'll start back a little after 10:30. Leave your notepads in the courtroom. Do not discuss the case amongst yourselves. You do not check any media sources or use your electronic devices to find out any more about the case you know right now. We'll call the deputy in the back and he'll tell you where to go for your break.
Okay, they skipped the break. Zoom, 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 zoom. Here's our break. Here's our break. Here's our break. Let's see, is this them coming back in?
So, how do you think it's going?
Hang on. Back up, back up. Defendant goes out. We have a hot mic. Hot mic. Hang on. We're not going to skip this. Judge is out of the room. Let's give it a second here. Where's she come in? Hang on. I was trying to skip it.
Yeah, it's back. Yeah, you didn't make it to each other. Yeah.
And I've got a call.
Call from K-Reb.
I'll take it off there. Hang on.
That tractor, let them walk around, stretch their legs and all the way there. That would be about a 10, 15-minute recess. Copy, that's fine. Go ahead.
That'll be the wrong back.
Yeah, I have the
So that's the yeah.
So, how do you think it's going?
Well, I told him
I think that you working with
That's not. I have no problem saying that to Jeff.
I'll ask the judge.
It's gonna be kind of, like that little wax of coverage.
It sucks. Him co-mingling, I didn't know him co-mingling until this morning. That really sucks.
Yeah.
The fact that.
You didn't know it till this morning?
I didn't know it till this morning. I thought this was only the stuff that was kind of in his pocket.
Oh.
I didn't realize this was,
It does look like a lot more than her.
which is kind of good for me though, because they don't look alike. And if this was what was in his pocket, my argument was gonna be just the same thing as what was found in that. And it's clearly not. So the fact that he commingled it, I think actually helps my argument to tie him.
Yeah, yeah.
It's like so much more. When he asked me at the beginning.
I mean, the stuff in his pocket, that's the same.
Oh, no, at one point he did ask, he asked where this one was, because I had brought this other stuff.
Right.
Cocaine in his pocket.
It's cocaine in his pocket.
Yeah.
That's what we know the asphalt fingers, because nothing that like that ever gets smelled.
But they don't understand that.
Well, right.
If there was an offensive, they'd ask the same question.
Yeah, and there's certain things that, FDA will accept and not accept.
He's doing a good job, and I told you this morning, I was,
What's his name? Process.
And you may get fingerprints off a container, but you're not gonna get them off the baggies themselves, no way. Yes. Wasted.
how do you think my officer did? Because he's.
Quickly.
Yeah.
To deal with.
I mean, he did okay. I mean.
Oh, it's funny, they said, you like to review our agency's policy, I'm like, damn.
Yeah, I don't like when they do that though.
Yeah, don't be popping like that.
Especially because then the judge says something and you're like, oh.
Yeah, okay. No, it doesn't. He started to get a little. Yeah.
Your analyst is always designed different.
Yeah.
What was it really about? Sure, there would be some markings of the panel city aides on their submit to FDLE.
There are.
Okay. When he said that it was where it came from.
No, yeah, no, like he was asking like where was it? It doesn't say like where.
Oh, specific, like on the shop.
Defendant's back. Everyone be quiet. He's here. Conversation stops. Jury's not here. These are prosecutors and court staff talking to each other. I didn't hear anything inappropriate. It was more like young lawyer, how am I doing type stuff. They didn't like that the police officer got a little snarky.
And I wouldn't charge that as trafficking and fentanyl offense.
So KRAB called during this and gave me some information about what Moors soft sits are like. Moors believe they are descendants of Morocco, and that it relates to an agreement where Morocco first recognized the United States as a country. But they believe they are not subject to any of the laws of the United States. They believe they also own all the land. And this particular witness did make statements to that extent during the traffic stop. We heard that from the testimony. That's where he says you're violating the treaty. They have. He says no. He said the coke was in his pocket, but the other baggies was meth. So there's no way to link them together. Apart from the fact they were similar baggies, he said no one noticed. I think the testimony from the officer was clear on that, though. Craig, I think the hot mic emoji is probably just for members. Got to get you in green, Craig. Make sure your gift memberships is turned to accept. 3 congratulations, 20 years. That's awesome. This will just be a partial day trial, I think. I'd be surprised if the jury deliberates for more than an hour.
Right, but no other cases besides this one.
It's hard to tell, but that it's supposed to be a hot mic image. I made it.
Yes,
Okay, we're going to skip ahead a little bit because the judge is here. Nothing spicy is going to happen with the defendant present.
Call back if you're going to testify.
Oh, here we go.
Yeah. When you say you don't testify, I'll release them. Because I was only going to call back if you were going to testify. Okay, so it's my subpoena.
So prosecutor just said, if you're going to testify, then I'm going to call my officer again because he can counter anything you testify to. If you're not going to testify, I'll release him because the prosecutor's the one that has the subpoena for the officer.
But you know, we all
back up.
Course you and admit that you came.
Here we go.
But Robert Bailey is just, absolute. I don't know. Evil is not even a word I would use. Evil's being nice. He just, you come down here and admit that you came and, that if you were bothered by law enforcement, you're going to kill a cop and say that, you would do it again if you had the opportunity. No. Yeah.
Talking about Robert Bailey. That sounded like the judge's voice there.
And I understand that, not majority of society doesn't like law enforcement, but, we all have a job to do. So, right, exactly. But it's pretty cool that his son is now in law enforcement. Kevin Kite's son is a beach cop now. Yeah. Been a lot of different scholarships and stuff been awarded to people too through that for big hat. That was in 2005.
Hot mic continues. A beach cop, that's the job. Uniform consists of shorts and a polo shirt, right? I don't know. Is this in Brandystown? I don't know. We're going to skip ahead a little bit. Judge is back. Here we go. We're in Bay County.
With the instruction on the methamphetamine, any issues with that? Page 2.
Yes, Your Honor, this, should this be stylized like for possession? Or element added?
Standard construction, Your Honor.
It's the standard construction.
We might skip through some of this.
It's the standard instruction on possession.
Jury instructions.
Stylized
No, sir. You been able to contact the officer?
Yes, Your Honor, he's on his way back.
Thanks.
Okay, I think we're about right here. Trying to get caught up.
Did Mr. Beecham have a break? Yes. Thank you. General rule.
Keep trying to skip ahead, and then he starts talking.
Just let me know when you're ready, sir. Any problems with the general rules? And then you may find that get defendant guilty as charged or in the information or not guilty. And it has to be unanimous verdict. If you had a chance to look at the verdict form, sir?
It's the last page.
Any objection? All right, and then the last is just a few moments to instruct the jurors about what they're to do when they get back to the jury room. If you'll make those corrections.
Done.
Okay.
Forward it to,
Do we know what the ETA is for the officer?
step out, he may be here, Your Honor.
Okay. And what we'll do is once Mr. Beecham rests his case, if there's no rebuttal, we'll go right into closing arguments. Any objection?
No, Your Honor.
Mr. Beecham, any objection?
Okay, so now we're getting the last witness, I think. Oh, nope. We're moving the podium because we're going to do closing arguments.
Not out all the way around, but he texted me, he's here, so I think he's working his way up.
Okay, well, let's go ahead. Are you ready to bring the jurors in?
I'm ready, Your Honor.
Let's go ahead and bring the jurors in. And then Mr. Beecham, when the jurors in, I'm going to ask all your first witness and you can call your witness, okay?
He does have a witness. Do you think it's his girlfriend? Got two juror members in the restroom. Just skip ahead a little bit until we see them walking in. There we go. Here comes the jury. Dream and Landry.
Everyone can have a seat.
Gifted membership.
Sir, when you get to your place, you may have a seat.
Went to Angela, LD.
Record reflect all the jurors are back in their place. And so, Mr. Beecham, you may call your first witness.
All
right.
He called the officer back. He's got more questions.
Going forward, sir, take your seat back there.
Same officer.
Officer, if you're still under oath, just have a seat speaking to the microphone. Mr. Beecham, you may inquire when you're ready.
Officers, you know that these are the two. I'm being being charged with.
Mr. Beecham, you may want to speak up where the jury can hear you, okay?
Okay, I'm sorry. Are these the two exhibits that I'm being charged with here today?
Yes.
Are any one of these the substance that was allegedly found in my pocket?
It was not in your pocket.
Good
And
question.
so the alleged substance that you said was found in my pocket was put with some other substance and weighed up separately, but not those two.
Correct.
That was
Okay,
that was good.
That's all. I just wanted to get that to the jury.
Okay. I've got no calls to the Your Honor.
Mr. Beecham, you call your next witness.
That would be, I rest my case, Your Honor.
Okay, any rebuttal?
No, Your Honor.
Officer Zip, you're free to go, you're released, and you're free to go about your day.
All right, thank you, sir.
So he basically got in that the part in his pocket was needed with the part in the back to
Okay,
get to the
State
15 grams.
The defendant have now rested their case. Mr. Sullivan and Mr. Beecham will now present their final arguments. Please remember that what Mr. Sullivan and Mr. Beecham say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Sullivan, whenever you're ready.
Thank you, Your Honor. Madam Clerk, if I could have the screens, please.
Please tell me you didn't make a PowerPoint for this case. Evangeline Light just gifted 5 memberships.
All right, ladies and gentlemen, as I told you earlier this morning, in a few moments, the judge will give you the law that will apply to the evidence that you've heard. I also told you this wasn't a complex case. It's pretty simple. Things may have gotten a little confusing earlier. I'm going to attempt to try to clarify some of that for you real quick. But like I told you, I have to prove 3 things beyond a reasonable doubt, count 1. The first thing that I have to prove is that the defendant knowingly possessed the substance. Second thing I have to prove is that that substance was methamphetamine. And the third thing I have to prove is that methamphetamine weighed more than 14 grams. The real issue in this case is that first thing, whether the defendant possessed the substance. I don't think that there's any dispute that these items are methamphetamine and that it weighs 15 grams, more than 14. You heard that testimony from the FDA analyst, Sam Catalani, and I don't think Mr. Beecham's even disputing that part. The question in this case is whether he knowingly possessed this item. I'm going to come back to that in a second. Count 2, I have to prove 2 things beyond a reasonable doubt: that the defendant knowingly possessed a substance. That's this substance here. And that the second item that I have to prove is that this substance was cocaine. Again, you heard that testimony from Sam Catalani. This is in fact cocaine. And I don't think Mr. Beecham's even disputing that. That's not the issue. The issue, like count 1, is whether Mr. Beecham possessed this substance. So I want to talk about that issue, because that's really what we're here for today. Is did Mr. Beecham possess these 2 items? You heard the testimony that these 2 items were found located in a backpack in the back seat within reach of Mr. Beecham being the driver. They were also located in, the reason I have it up on the screen, it may be easier, but I'm going to try to point here. So in states 1A, this item up here at the top, that is the methamphetamine in this case, and that is also the same item that is depicted in 1C. And this is how it was found. It's just a close-up view so you can better see how it was found. This container here on the left of the photograph, that is where the cocaine in this case was located. That was found in that same location as the methamphetamine. Now, there's some talk about commingling drugs, mixing it together and where it was found and all that. This item, State's Exhibit 4. You heard the testimony, this was not tested by FDOE. So the officer testified that he did a field test and the field tested positive for cocaine. At the end of the day, maybe it's cocaine, maybe it's not. Mr. Beecham's not charged for this substance, for whatever it is. But this substance is important because it directly links Mr. Beecham to these items. And it directly links Mr. Beecham to these items that he is charged with.
That's not rule the objection to start. Chance to make your argument. Okay?
It directly links Mr. Beecham to these items because you heard the testimony and you can see the powder. It's all the same powder. And the fact that it was actually mixed together is a good thing because if it was different, you would see the difference. And if you compare the color it's different than the other items. But this white powder came from this container that was located with these items that Mr. Beecham was charged with, as well as the bag that was found in Mr. Beecham's pocket. And that's important because, as you heard the testimony from Officer Zip, he had the same exact thing in his pocket that was located with these other items. Now, you heard some testimony about oxycodone, marijuana, fentanyl, things like that. You heard the testimony and saw I showed some exhibits to Officer Zip. There were some other items that were found along with these, but those items, again, were not sent to FTLE, they were not tested. So Mr. Beecham was not charged with those items. We talked a little bit Monday about some rules, and when I talked about objections, there's rules we have to follow. Typically, I'm not allowed to present items of evidence that Mr. Beecham was not charged with, the oxycodone in this case. So when I had Mr. Officer Zip on the stand and we were talking about what was found originally, he wasn't hiding anything. He wasn't hiding the fact that there were these pills found as well. I'm not allowed to present that to you. Mr. Beecham decided he wanted to talk about it, and at that point, now we can talk about it. And that's why I got back up on redirect and we were able to present it to him. I only bring that up because Mr. Officer Zip wasn't hiding anything. He wasn't being evasive. It's just the rules didn't allow me to do it until Mr. Beecham talked about it himself. I say that all to say is, again, Mr. Beecham's not charged with that. Don't take that into consideration. What he's here for today, simply these two items, methamphetamine and the cocaine. And the importance of this other exhibit is because it directly ties Mr. Beecham, not only because he's in direct physical control, the ability to reach around and control those items, but because he actually had some of those items on his person. Knowledge of an item, the judge will tell you that the state has to prove that the defendant knowingly possessed these items. And there's no way for me to prove the knowledge that's in his mind. It's impossible. You have to infer knowledge. And you infer knowledge based on the other circumstances in the case. In this particular case, you can infer that the defendant knowingly possessed the items in the back of the car because he had.
Overrule this argument. You'll get a chance to respond.
You can infer that he possessed the items in the back of the car because he had one of those items in his actual pocket. I submit to you that this case is not complex. I have proven the charges beyond a reasonable doubt. In a moment, when the judge reads you those instructions, you'll see that. And I ask you to find the defendant guilty as charged. Thank you.
You're ready.
All right, ladies and gentlemen, if you weren't able to hear me quite clear today, state wants you to believe that I possess the two drugs that were there wrong. You heard from the officer, I wasn't charged. I mean, with those items wasn't on me. The one alleged was on me, say it was in a bag. He wasn't able to show you the bag to show you that it actually was the same bag. And like we said, that we're in a day of technology, we're in a day and age of technology. There was a camera existing, somehow I miraculously cut it off. On top of cutting this camera off, the items were in, like y'all seen, a container, and he said a brown paper bag. It's easy to fingerprint those items. I was in the car with another occupant, and in a jointly occupied vehicle, you cannot infer.
Objection, Your Honor, misstatement of the law.
Sustained.
Well, I was in the car with another occupant as well, as you heard the officer say himself. And he said he lost sight of the other occupant when he was taking me out of the car. And we somehow lost all the footage of any items being found. And no items were scientifically tested to prove my, knowledge of these items. To prove that I had any ability or ever even came in contact with the items. They were in a brown paper bag, something that can easily be tested for prints. And he also said, you saw the containers. And so never, I can't dispute the weight or any of that because I didn't even know those items existed. And that's what I was trying to prove to you guys today. And the other items that supposedly ties me to the drugs allegedly found in my pocket, like we say it wasn't video capture because I turned the camera off. That was a discrepancy of saying that he allegedly found something and put it with some other stuff to say that I had a bag or known of another bag, but I'm not even charged with it. So I had a drug on me that connects to other drugs, but I'm not charged with that drug. I'm just charged with 2 of the other drugs out of the bag. If that makes sense. That's what the state is trying to get you to believe that. Or whatever was allegedly found, whether it was a drug or not, if that makes sense. So I'm not even getting the sense of how the state is trying to elaborate this, but I know that it was a way to prove beyond a reasonable doubt that I had knowledge or was able to access dominion and control over something that was, you know, like they're saying that was in my reach, but it was in a car with another passenger was in the car with me. And therefore, I'm asking you guys to find me innocent of this case because there was no prints or anything that connected me to those drugs. Thank you for your time.
Asked to find me innocent because they're not mine. That's what we hear.
Talk a little bit Monday about possession, whether it can be joint. Yes, there was another person in this car. You know, he'll have his day in court. Another jury will determine his fate. You know, just because there's 2 people doesn't mean multiple people didn't possess these controlled substances simultaneously. Mr. Beecham said that there's no scientific testing done. Well, that's not true. You heard the testimony from Sam Catalani. That's scientific testing. He told you that scientific analysis told you that, or confirms that this is cocaine and this is methamphetamine. Same white powder, same packaging, both with the controlled substances and in Mr. Beecham's pocket. And that's the key to this case. Simple as that. You know, this isn't a case where it's in a different packaging, it's in a different container, it's a different substance. It's the exact same thing. It's the same white powder and it's packaged the exact same way as the stuff that's in the back, in the backpack, in the back of the car. As far as the body camera goes, you heard the testimony as to why there's no footage of this. Mr. Beecham's the one who was not cooperating. He was struggling with the officer, and Mr. Beecham's the one who accidentally turned Officer Ziff's body camera off during that struggle. It's as simple as that. It's not any big conspiracy that Mr. Beecham wants you to believe. It's as simple as that, ladies and gentlemen, and I ask you to find the defendant guilty. Thank you.
All right, on to jury instructions.
Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Josiah Marquise Beecham, the defendant in this case, has been accused of the crimes of trafficking in methamphetamine, possession of cocaine. As to count 1, certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of trafficking in methamphetamine, the state must prove the following 3 elements beyond a reasonable doubt. Josiah Marquez Beecham knowingly possessed a substance. The substance was methamphetamine. The methamphetamine weighed 14 grams or more. To prove Josiah Marquez Beecham knowingly possessed a substance, the state must prove beyond a reasonable doubt that he knew of the existence of the substance and intentionally exercised control over that substance. Control can be exercised over a substance, whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Josiah Marquez Beecham had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, 2 or more persons may possess a substance. As to count 2,
Certain drugs and chemical substances are by law known as a controlled substance. Cocaine is a controlled substance. To prove the crime of possession of cocaine, the state must prove the following two elements beyond a reasonable doubt. Josiah Marquez Beecham possessed a substance. This substance was cocaine. The definition of possession was previously read to you as a part of count 1 and applies equally to count 2. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or to prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You should not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the laws that is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must be decided for, this case must not be decided for or against anyone because you feel sorry for anyone or angry with anyone. Remember, the lawyer is not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Verdict. We, the jury, find this defendant, Josiah Marquez Beecham, as follows. Mark only one. The defendant is guilty as charged of trafficking in methamphetamine. The defendant is not guilty. That's count one. Count two. The defendant is guilty as charged of possession of cocaine. The defendant is not guilty. Mark only one of those. Signed by the foreperson and dated. A separate crime is charged in each count of the information, and although they've been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on the verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or other electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberation. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, smartwatches, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats or they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note to the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with Mr. Sullivan and Mr. Beecham before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I'll answer any questions if I can, in writing or orally here in open court. During the trial, items will receive into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent to the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the law that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Mr. Sullivan, Mr. Beecham, does that actually reflect the jury instructions agreed upon?
Yes, Your Honor, sir.
All right. Ladies and gentlemen, just a moment, you're going to be escorted by the bailiff to the jury room. Ms. Rutgers and Ms. Moncare, you are also jurors. You will not go back and deliberate. And I apologize. I know that keep you all day Monday and keep you all morning today. But we have to have 6 jurors, and many times we pick jurors on Monday, about time Friday, we have jurors that cannot serve, so that's why we have alternates. I let everybody else know that, because I've sent a jury back in the jury room and didn't tell them why the other jurors didn't go back, because they were alternates. And they waited for 45 minutes before they started deliberating, because they did exactly what I told them to do. So that's why I let you know that. We'll send all the evidence out there with them. Here are the instructions, also the verdict form.
They're sending all the evidence back, all the
Leave all
drugs.
your electronic devices, your pocketbooks, any smartphones, leave them in your chairs. If they can the sheriff's office will be responsible, they will be secure.
It's your choice to stay here in the courtroom or leave.
If you can stay in the courtroom, and I'll talk to you. Don't just stay where you're at. I'll talk to you.
Okay, so the jury is deliberating right now. They're headed out. We're not going to do a timer because we're like 10 minutes behind actual time. Jury goes out to deliberate. They may not even get a lunch break. They might not need one.
I certainly appreciate your service. We could not do this without alternates. Many times, I've run out of jurors by Friday. My people too, because I've run out. Don't have to see. But you have provided a great service to your community, other than serving in your country's military. This is the highest honor we have. This is the highest honor we have for civilians. Come and sit as jurors. This separates us from the rest of the world. With that being said, that concludes the jury service. Go back and start your weekend, or feel free to sit in the courtroom and wait on the verdict. But thank you. You're free to leave. Gentlemen, thank you for a well-tried case.
Thank you, Your Honor.
Yes, sir.
Reinstate the motion for judgment on the court.
Absolutely. And it'll be the same rule. All right, Mr. Beecham, that's a well-tried case. We'll be in recess until we hear from the jury. Mr. Beecham, I'll take you back to the back.
There we go. That quick. Apparently we were supposed to go to Judge Boyd now. They're in break right now. They're in break. We are waiting for... We're waiting for the new live stream to come up. Let's see. Go to channel. So we haven't had anything. It's been 15 minutes of deliberation, and that's it. That should be long enough, I thought. What evidence? What pictures of the drugs? They actually provided the drugs. There were pictures of drugs and then the actual drugs. Do we get verdict music? Of course we get verdict music. We'll have it as soon as we see something. Get verdict music on a Friday. Demand a recount on the drugs. I think they need to be reweighed after they come back from the jury room. I'm not accusing the jurors of anything, but I think they probably need to be reweighed just to make sure we still have 15 grams. And that all the little multicolored pills are still there. Come on. Let's see. Ooh, Vicky says don't make the jump to Boyd today. Not the one you want to watch today. Okay, thank you, Vicky, for the heads up. Turns out it was only 8 grams. Go figure. Sarah Boone hearing did happen today. For a recap for those who missed it, let me give you the short version, because it was short. It was very short. What happened is Sarah Boone appeared in court physically with her lawyer. That's what she wants. She wants to be there for all of her hearings. Her lawyer, Attorney Cashman, was there. Sarah Boone has an issue. Well, multiple issues with her lawyer. They don't get along. Similar to all her other lawyers. She has some complaints about how the lawyer is handling things, about the attitude her lawyer has with her, how she was snotty to her. She has complaints saying the lawyer has lied to her, has prevented her from getting a bond hearing, and we're not doing a verdict clock. It's going to be too short. It's just not going to work. Let's see. Go back up to. She says that her attorney lied to her, and she hasn't asked for a new attorney. She just wants the attorney to do what she wants, and so far, that's not happening. Hang on, was that 1 year ago? have to keep checking. Is anyone volunteer to keep refreshing 14th Judicial Circuit of Florida, which is at 14th Judicial Circuit 01005 on YouTube, just to make sure we don't miss the verdict when it comes in any second now. Check out Chad's new mug shot. I will do that now. Anyway, so Sarah Boone, she has all these complaints. The lawyer, the judge listened to Sarah Boone, talked to her, and said, spell this out for me. Exactly what's happening. How did she lie? In what way is she not representing you properly? And everything she brought to him, the judge said, yeah, sounds like they're doing their job. But Sarah has a packet, an envelope, a manila envelope that she delivered to the judge through the bailiff. In there, we know there is at least a letter from Sarah to the bailiff and possibly other documents. It's probably prior stuff that this judge was not familiar with as well. So we're waiting for that document to be dropped into the docket because it will be scanned and added to the records that are on her docket. So let me just do a quick check on that one right now. Make sure it's not there yet. Still not there. All right. So the lawyer talked to the judge as well, mentioned that maybe the best thing for her would be to represent herself. That's been a common theme that we've heard from all of her lawyers, especially the ones that want to get released from serving as her lawyer. But the judge said he'll listen to it. He might order a hearing for bond. If she does get a hearing for bond, Sarah Boone, who has no money, has said that her fans would probably do a GoFundMe or something and would raise the money for her bond. She has letters. She mentioned she got the last one was from South Korea, so she knows she's famous around the world. And she thinks that might just help her out a little bit. It is concerning, as one of you brought up, that Sarah Boone is more interested in raising money for bond than she is for raising money for a lawyer. I think you'd think it would be better to have a lawyer, a good lawyer, than just a low bond. That would indicate flight risk in a big way. Hopefully not OnlyFans. Judge Fleischer. I can't jump off this very easily, so I've got to keep this one up in case something happens. I believe she would argue with herself. At what point does the court stop playing her game and give her revolving doors of lawyers? Well, they haven't changed her lawyer today. There is going to be the only things they scheduled was a trial scheduling hearing on 9/24, and then the trial itself, I believe, is 10/7, 10/6 or 10/7. I'm looking for Chad's mugshot really quickly. I was doing that and I got sidetracked. Chad Daybell mugshot. Oh, wow. New mugshot released. Let's just, let me bring this over to camera 3. Can I do that? This is just over Judge Boyd, but it'll work.
But then in the cross-examination, we
don't want to hear Judge Boyd. There's Chad Daybell's new picture. It's like a yearbook photo, but for jail. It looks like he's completely surprised by the verdict. But there we go. His previous, let's see if I can show that one. His previous mugshot, just to show you the age progression. Right here. Don't mean to scare you guys by having his face too big, so we'll shrink it down a little. Here's his previous from Ada County. So there was that. The storm. The storm's coming. Oh man, you guys are terrible. Let's see. I think we're ready. Do we want to wait for lunch to see if verdict? If we go to lunch, I'm sure a verdict will come in immediately, because that's how it works. Shut down to Judge Boyd. No verdict yet in the 14th Judicial Circuit. Angela says, did Chad get the death penalty? Yes. Times 6. Got 6 of them. Not sure which one they're going to carry out. Maybe there's to be served concurrently. But yes, he's on death row now. He's already motioned for, or has already given notice that he's going to file an appeal. So there are quite a few appeals. It will take a long time. So consecutive death penalties. It's if you're studying the death penalty in the United States, it's an interesting area. It's an interesting area because the states have to make sure first you're healthy enough to die. And I've never wrapped my head around this properly. But if we, as a people, using the jury system or the judge, however it goes, determine that after a fair trial that you are no longer worthy of living, it's like as punishment you have to die. You should stop taking up our air. I mean, I don't know how much more blatant a statement it is, but you should no longer be living. One of the last things that happens is we give you a good meal for the journey, I guess, I don't know, and you get a physical. You get a doctor who checks you over and makes sure that you're fit as a fiddle and ready to go on to the next step, which is not being fit as a fiddle. And that's the last step to make sure you're actually dead. I don't know why. I don't know why. If they were like, if they had a broken leg, it's like, look, we're going to put you out of your misery. Okay? You're dealing with something. Guess what? You won't be dealing with it long. Why do we wait till they're better and then kill them? I don't know. I need somebody smarter than me to explain. Get well soon, yes. Oh, my goodness. Get well soon. That's terrible. Gordon, I'm sick today. Can I get a pass on the death penalty? What would my last meal be before execution? Probably what I just ate today. I had a salad. It was garden salad, so that's going to be lettuce, shredded carrots, and the purple stuffed cabbage. We had cranberries, bacon bits, barbecue chicken, sliced mozzarella cheese. What else was there? And Italian. I'm a big fan of the Italian from Olive Garden dressing. I said bacon bits, but actually it was like bacon. It was like two strips of bacon. But there was salad there. There was lettuce. Last meal would not be a salad. I guess, from a strategic standpoint, I'd want my last meal to be something that made me very sick. Would that be it would elongate, it would stretch things out. Because then I couldn't go on to the next step. I'll go for fondue. I haven't had fondue in ages. I've actually never had fondue where you cook the food. I've always done like the chocolate fondue version, where you have like sweets that you dip in chocolate. Sorry, you have the runs. We can't on a live view now. That's it. Oh, fish and chips. That would be worth not getting sick over. Good old fish and chips, not like they serve here in the United States, but like proper fish and chips served in a newspaper, covered in salt and vinegar. Not the weak stuff we have here, but the real vinegar from England. That would be really good. There goes my diet. It gives you additional 5 years. Malt vinegar. Oh, I love malt vinegar. I'm not super picky on what type of fish it is. Cod, halibut. Of course, I do like getting fish and chips just for the halibut, but rejected juror says, I'm back. Fish and chips drew me in. Now I need French fries. You're not allowed to use newspaper now? Can you at least use like some butcher paper? Because that was the good, you always got to, it was like dinner and a movie, only you got dinner and the yesterday's news together. Tell you one thing I loved eating over in England that was really good. Sorry, we're still on verdict watch, by the way, as we stall here. I'll keep an eye on what's happening. Not back yet. There's I don't know what it is. It looks like I've told you this, I think, guys. It looks like an elephant leg on a spit. There's a burner on one side and the elephant leg turns, and it only cooks the very outside bit, just the thin layer on the outside. Inside is like raw and poisonous, I think. But they have like this knife that's like 6 feet long, and they have a huge long blade, and they're like it's like a sword. They cut the meat off with a sword. It's a kebab, but they do and they cut the meat off, and you don't want them to cut too much, and you don't want to order the kebab. You don't want to be like the fourth guy in line to order a kebab because the meat on the outside hasn't had a chance to cook, right? You want to be the first guy, so it's nice and cooked. But oh, that's good. I don't even remember what I ate it in or on or with. You know I can't say that word. I call it a gyro, and everyone's like, no, it's a hero or something. It's lamb. That's okay, we make lamb. A filthy kebab after a night on the drink is top tier. You want the crispy meat. I don't want it crispy, but I just want it cooked. A gyro. Hero. Okay, hang on here. Does anyone else see the irony in this situation? The way I say kebab is funny to hear. Welsh lady, you have one of the most beautiful accents ever. You crack us all up. And I say it wrong, apparently. Gyro. Okay, sorry. I've got one job to do, and it's to watch for court. I'm neglecting it. Just 1 second. Is anyone else looking for me so I don't have to do it? We always come back to food. It's Friday. It's Friday. You're saying kebab, not kebab? It's a kebab? 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 It's a kebab. I don't know. You say kebab like it's keb. Correct me if I'm wrong. Help me with the pronunciation, Welsh lady. Just of this part. I would say that as Bob. Bob. Okay? Bob. I've got a phone call. It's probably Welsh lady.
Call from Angela.
Oh, it's Angela. Even better. Angela, are you here to make fun of my pronunciation?
No, I'm not.
How are you doing?
Because I live in Sweden. We pronounce as you write, as it gyros. So yeah,
Gyro?
I think Greeks are also gyros.
Do you roll the R there? Gyros. Gross.
Yeah.
Like that. You say it's gross.
Yeah. Gyros.
Oh, gyros.
Yes. Yeah. And by the way, a little known fact from people that actually run the gyros restaurants, at least here in Sweden, at least here in Europe. Those meat that you see going around, do you want to guess how many pieces of meat they go through every day?
I always thought they had like one piece for like the week.
Maybe in U.S., not here.
How much?
Like 3, 4.
Wow.
It depends on the place. Maybe even more if it's some popular place or some like huge place.
I've never seen a restaurant here in the United States where they show you the meat cooking, and maybe that's for the better. But I was always nervous.
Try Chicago.
All right.
Chicago.
Hey Siri, how much are flights to Chicago right now? Oh. I'll have to go to Chicago and find a place that will do that. I've never been to, I think I've been to the airport, O'Hare.
Well, there is probably other places, but I do know there is for a fact in Chicago because there is a whole neighborhood called Balkan neighborhood, something along that line. So you can find Balkan restaurants there. You can find authentic Balkan restaurants and shops and so on and so forth. So yeah, so I know for a fact there is there, the true one at least.
Okay.
The original one.
I'll have to look for that. I need a good chippy. If I can find a place that cooks fish and chips here in North Carolina, like they cook them in London, screw the diet. Screw the diet. I would just be like, forget it. You know, it's not worth it. I'm going to be your best and only customer probably because I'm going to buy out everything you got.
Well, fish and chips have been ruined for me actually, and I still eat it. I mean, I ate it a few weeks ago, but every time I think of fish and chips, I can't help but think of another thing. The place where I work, well, I don't know if I'm going to continue in the fall, but for now where I worked is they do all kinds of experiments, including anything related to climate changes. And they take samples from different cities around the world, and they took a sample from London air. They take air samples and analyze it. So they took a sample from London air, and they analyzed it. I don't know how big the sample was, but a promille of that sample. Do you want to guess what they found?
Probably nothing healthy. Very little oxygen. What did they find?
Fried particles.
That sounds right. There's a chippy on every corner.
Yeah.
It's the flavor in the air. It's like when you walk outside of a barbecue grill place. You can smell it. But in England, it's all of that. I will say that England is the only place I've really had to chew my air before I breathe it, especially in London. There's some areas where it gets pretty thick in there. But
now you know the reason why.
It's just extra flavor.
Well, yeah. Actually, I am from Balkan, from Serbia, and it has changed a little in different parts, but at least where I am, if you are a vegan or vegetarian, you're practically starved to death because there is the only option for you is salad. Yeah. And most likely not the vegan salad.
If there's not enough vegan food around, the problem is my food is eating your food, and there's just not enough for you. That's the way it goes.
And around around every corner there is either a butcher shop or anything meat related. Or so, yeah. But I don't know if they tested any air there. So yeah, but yeah, I just wanted to, because of all the fish and chips and gyros, I just wanted to call and say that fun stuff that I just told. And I forgot to say hey to the chat. I do not see the chat right now, so I don't know if anyone is writing anything.
They're talking about the flavored air right now, and how good it tastes. Oh. Yeah, there's the
well,
air.
I did. Well,
when you go in the underground, the air in the underground is not good. Okay, because that smells like oil and metal and 200-year-old dust. That air is not good. And so, like, if you just stand right by the tunnel when the train's coming through, it pushes all the air and there's just a big rush of wind. That stuff will kill you like with 3 breaths. Okay, instant cancer, dead. That's no good. But upstairs, go outside, down some of the roads. Oh man, you start smelling all the fish and chips and the fries. Well, the chips are fries. That's good stuff.
Yeah. Yeah, I during Eurovision there was, in the Eurovision village there was a food truck, and I knew the owner because I worked on a food festival for him one day. It was not, the food festival was like a week, but he needed help for one day, so I got to help for one day. So I know how to make fish and chips, or at least I should remember the authentic fish and chips, at least.
Send me the recipe or make a video so that I can follow it.
If I can remember, because it was like 2017, so it was like what, 7 years ago.
Mm-hmm.
Now, yeah.
So I've got a request from Ivy Berlin saying, please ask her to pronounce the IKEA meatballs.
In Swedish or English?
Let's do both. Cover our bases.
IKEA, Swedish, IKEA's köttbullar. And in English, IKEA's meatballs.
IKEA köttbullar?
IKEA's köttbullar.
Köttbullar. Köttbullar? Lard? Yes. There's a rolled R in there.
Lard.
Lard.
Well, if you're from Skåne, then you are rolling your R. You're rolling the R. If you're up north, it's a strong R. Depends on where you are.
I've got ancestry that hails from Oslo, Norway. So I've got a little bit of that in me. Yeah. What does that do?
What, you got what?
A little bit of Norwegian from Oslo.
I think it's a strong R, not rolling R.
Good.
Yeah.
I'm strong. That's what I heard.
But it also depends where you are. Like when I was in Stockholm a few years ago, and he was like, "Are you from Skåne?" He directly it's like the south of the Sweden. We from the south have a very distinct. What's the name? Dialect.
Okay.
Then from up
I was going to go with aroma, so I was way off.
Yeah. So and yeah, that was everything. So yeah. Yeah. Thank you so much. And what? Oh, sorry, I have one more thing.
Yes.
Another from Sarah Boone.
Yes.
Seriously?
This is what I want to talk about. According to some my mods who are talking about this right now in mod chat, 58 pages. She came with 58 pages. It's going to be the longest read ever, but we will read it. We'll read it. It sounds like she probably brought old copies for reference. I don't know how much of this is new because that's more pens than she's used her entire incarceration, I think. But
oh my God,
we're going to read the entire thing as soon as it gets posted.
Yeah. So yeah, that was everything. Thank you so much, and hi chat again.
Angela, it's always great to talk to you. Thank you so much.
Thank you. Bye-bye.
Bye. All right. Thank you for the call, Angela from Sweden, helping us pronounce IKEA meatballs, which is, I guess, crucial to starting your weekend. All right, still waiting for a verdict. Not seeing it yet. Could we have a hung jury again? How many hung juries have we had recently? Obviously, the one we just had right now, which was a sort of hung verdict, that was going to be in Tennessee, the David Swift trial. Right before that, the hung jury we had, I believe, was the Kelly trial. There's two. Was there another before Kelly? So we had the hot tub cold case and the Arizona Rancher. This is the condensed version. This is the Cliff Notes. She just brought the short version. The judge dismissed the jury. Did they already have the verdict? He just dismissed the extra, the alternates, I believe. The rest went to go deliberate, and I have not seen them come back yet. We'll play some mood music. Oh, Treehouse Trial. You're right. Treehouse Trial was the other one. And it's 70 people said that, and I just barely saw that. So we've had three mistrials. Volume 1. That's chapter 1, Dwayne. That's chapter 1, 58 pages. Emily, we're waiting right now. We had a little court case. It looked like this right here.
The officer testified that he
was
did a
it.
field test.
It's out of Florida, 14th Circuit out of Florida. Just a simple cocaine possession, cocaine and meth possession in distribution amounts case. Pro se defendant did an okay job. Nearly got some of the evidence excluded. Some of the drug evidence excluded because of a test that came back faulty on scene and then tested as something else later. Ended up the judge overruled that at a sidebar, but did okay. A little quiet. He probably would have done a lot better speaking up, but sort of held his own. Did open the door for other drugs that he was not charged with, that he was caught with, like fentanyl and marijuana. He opened the door for those to come in, which was a bit of a oopsies. And also brought in the testimony through his own cross-examination of the police officer that he fought with the police officer and he was a bit of a handful. But you're not hearing anything? Test 1 2. Why is it going quiet? Check 1 2. Check 1 2. Testing. Test 1 2. It did get quiet, and I don't know why. What did I do to make it quiet? Anyway, I will be watching for those 58 pages to be posted on her docket. And once it does get posted, we're going to do a live stream, just like we have with all the other letters. And we'll go ahead and share those. So far, nothing. Volume's here. You hear fine. That's great. We covered Sarah Boone this morning. I should probably move Sarah Boone to the last part of the message. Let's flip it from court hopping, Friday court hopping, and then Sarah Boone hearing as well. Because we did cover that hearing already. Okay, thanks for the reminder. Now it's going to make a little more sense when people come in and they say, "Hey, where's Sarah Boone?" I fixed it already. Mel. The lawyer I worked for often told the story of how badly the prosecution messed up when they didn't make room for additional drug charges after a search. I have to admit, the defendant was terrible. He was not the best. The problem is, Dwayne, and this is, by the way, welcome. Good to have you here today as well. The problem is the defendant had a couple issues in his case that he probably could have gotten some mileage out of, and it could have helped him out. And obviously, the verdict's still out; it's not back yet. So it maybe he did. Maybe he'll come back and be acquitted. But I think an experienced lawyer would be able to look at those issues and run with them and get more out of them than he did in his case. Although he did sort of cover them a little. more court hopping while we wait. We can. I just let me make sure. Who do we have here? Let me check this one more time. Not back yet. Let me try it on this one. Judge Boyd is in a trial that's content we don't want to follow. Let's see, Judge Cedric has been private all day, so nothing in his courtroom. We do have something going on in Thurston County. We did say we wanted to keep an eye on them, so just 1 second. Let's see who we have. States, what's a CAC calendar? CAC. For some reason, I can't remember what that is. Let's see which courts are active. Let's see, Court 1. Court 1 is live, just district court. I'll bring this one over.
For the next year, you're not to commit a criminal law violation. You're not to drive a vehicle without an ignition airlock if the Department of Licensing is requiring one. Not to go to any bars or taverns, not to drive without a license or insurance.
Why does he look taller on the right than he does on the left?
I am, because the Alcohol and Drug Information School has not yet been completed, I am going to go ahead and impose no alcohol, marijuana, or non-prescribed drugs. And that really does mean none. Don't refuse a breath or blood test if one is requested. You'll be on monitored probation, which is just a records check. As long as you stay out of trouble, you won't have to call in and talk to probation.
Or test.
I am indicating that you need to get the substance use disorder assessment and any follow-up treatment. I'm also indicating that you have completed the evaluation and the victims impact panel that I'm ordering. But you still need to do the Alcohol and Drug Information School.
There's a lot of things.
You need to do that Alcohol and Drug Information School by August 12th, unless other arrangements are made through the court, through your attorney, or with probation. Do you have any questions at all about that sentence?
No, I do not.
Okay, you can get a copy of that from your attorney or from the court, either in person or online. And that will be it for today. Good luck to you. Hopefully we won't see you back in here again.
Hope I never see you again.
I think you're saying internally, yeah, that I don't want that to happen.
Yeah.
Okay. All right. You have a good day.
Yep, you too. Thank you, Your Honor.
Thank you.
Any more
All
cases?
right. Next case that's ready, Mr. Gaslin.
Your Honor, I would defer to Attorney Capone. I believe she needs to.
Actually, Ms. Simmons has jumped in.
I believe Attorney Capone has to prepare the in-custody calendar.
Oh, we've
today.
seen.
She has things to do. A bit of a time restriction there.
Okay, with that time restriction.
I appreciate the court and Ms. Simmons' patience. She's about to die, so I'll plug in. But this with me today is Ms. Maris. She is number 6 on the 9:30 calendar. And the intention is to enter into a plea.
Okay. Good morning. You are Devery Maris?
Yes, sir.
I have a mailing address for you. Starts 79.
Yes.
Are you getting text message reminders for court?
Yes.
I want those. Text message reminders for court.
I have a document in front of me titled Statement of Defendant on Plea of Guilty. Have you had an opportunity to go over this with your attorney?
Yes, sir.
And were all your questions answered?
Yes.
Drug
This
case
tells
still
me
with
the
the jury.
charge is DUI. Elements in the charging document, and you have some rights, such as the right to a speedy trial, the right to hear and question witnesses, the right to testify or remain silent, the right to be presumed innocent, and the right to appeal a finding of guilt after a trial. You understand, if I accept this, that you are giving up those rights?
Yes, sir.
There won't be a trial? Okay. There's a recommendation here, plead guilty to a DUI no test. Mandatory minimums, 1 day or 15 days electronic home monitoring, 363 days suspended for 5 years. Otherwise, standard DUI conditions. Is that your understanding of the state's recommendation?
Yes.
You understand I don't have to follow that?
I do. Yes.
I see the citizenship discussion has been held, and you understand that there are mandatory minimums that I wouldn't be able to go below. I also see and want to make sure you understand that there will be a license suspension of at least 90 days.
Yes.
With all of that in mind, how do you plead
Guilty.
to DUI? Thank you. I heard your answer.
She's like, I'm guilty. Don't read the whole charge. I'm guilty.
Has anyone made any threats or any promises except what's in this document to get you to make that plea?
No.
There's a statement here. It says on December 4th, 2023 in Thurston County, you drove a motor vehicle while under the influence of alcohol and that there was no admissible breath test obtained. Is that your statement of what occurred?
Yes, sir.
Accept your plea, find it's made knowingly and voluntarily with full understanding of the consequences, and there is a factual basis. And having done so, I'll hear from the state, please.
Your Honor, this state asked the court to follow the agreed upon recommendation.
Thank you. Ms. Capone.
Your Honor, we're asking the court to follow the recommendation as well. This is I think, more than fair agreement. Ms. Maris has no criminal history, although partway into me having this case with her, Fife filed a case that predates this. So we've been trying to navigate that, and Ms. Maris intends on entering a deferred prosecution in Fife on that DUI charge. Acknowledging that she is very young and she has no criminal history, I think that the treatment that is needed of her is going to be addressing the issues that have come up. And I don't anticipate seeing her before this court again, or the Fife court again, or any court again. She says that she's tired of dealing with these criminal charges, and I don't blame her. With regard to some of the affirmatives, she's already began working on them. I've shared with prosecution and Ms. Lopez for the court a victims impact panel that's been completed, a substance use that's been evaluation that's been completed, and an intake letter from New Directions. I did speak with New Directions yesterday, and they told me they'd have her May compliance report to me by the evening, but they didn't. But she did she's been now in treatment for a month. And I have filed with the court a request to have the SCRAM device removed from Ms. Maris now that she's engaged in treatment and shown 150 days of compliance with that SCRAM device. That substance use evaluation also recommends a mental health evaluation. Ms. Maris said that she had that done. I'm going to have to follow up with New Directions to make sure that gets to the court. And she said that there was no further treatment recommended on the mental health side. But she's currently engaged in treatment. She's going to be engaged in treatment for a while now, and will be monitored not only by this court, but the Fife court. DUI carries some pretty hefty mandatory minimums in terms of fines. So we'd ask the court to waive any that are discretionary. Ms. Maris has worked very, very hard to get her license back. And I did tell her to check in with the DOL. I know that 90-day license suspension can sometimes take from when you were previously suspended and count. So I told her to check in with them, but her job does require her to drive. So she's been working adamantly with the DOL to make sure she has a good license. And then with regard to jail time, we'd ask the court give her a little bit of a buffer to get her affairs in order and either figure out how to get hooked up to EHM or turn herself in for that one day. I'd ask the court to give her maybe 3 weeks to have that turned in. Thank you.
All right, thank you.
We're back. Hang on. Thank you, Amber. I think that was Amber.
Ms. Maris, we've heard from both attorneys. You have the right to address the court before I announce any sentence. Is there anything you...
We'll never know. We'll never know because we're going back to court here. Right here. We're back live.
My understanding that the jurors have reached a verdict.
You know what that means? It took less than an hour for the jury to deliberate. Only 2 witnesses were heard. Pro se defendant did his best, but they were able to reach a verdict.
Jurors have a seat. My understanding that the jurors have reached a verdict. Is that correct? Who's the full person?
I am too.
Mr. Is it Cannell? Go hand the verdict form.
Verdict form is right there on the bar. Bailiff takes it up to the judge, and he's going to review it here. Wow, we haven't had a verdict music in a while.
All right. Mr. Beecham, you'll rise. Madam Clerk, if you'll publish the verdict.
In the Circuit Court, 14th Judicial Circuit, State of Florida, in Recovery County. State of Florida versus Josiah Marquise Beecham. Case number 23 CF 4175. We, the jury, find as to the defendant, Josiah Marquise Beecham, as follows. Count 1, the defendant is not guilty. Count 2, the defendant is not guilty. Would say we all dated the 7th day of June 2024. Foreperson, Nicholas Cannell.
Does anyone wish to have the jury polled?
He beat it.
All right.
He beat the charges. Pro se for the win. Did you see the prosecutor throw his chair back and spin around? Oh,
ladies and gentlemen, I wish to thank you for your consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you're at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might simply find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your time, your consideration. Thank you for your...
Oh, they killed the feed. They killed the feed. It's done. It's done. Oh, wow. I don't believe it. I don't believe it. He beat the charges. That is just, I never would have guessed. They've got bags of drugs they found in his car. I'm muted. Why does it say I'm muted? Gordon, can you not hear me? Can we rewatch the prosecutor? Oh my goodness. Let's see. I want to see. Oh my goodness. They deleted it just like that. They deleted every copy of that court case. They pulled it down. Older ones are still up, but that one is down. That was wild. That was wild. A pro se defendant, he was charged with distribution, 15 grams of meth and cocaine. He also had fentanyl and marijuana in his area of control. He was the driver. He had some in his pocket, according to the police. But I think the kicker here was the body cam of the police officer who made the arrest and did the search was turned off during it. And the jury didn't even watch the body cam. There was no body cam video submitted. It was only told that it was on for part of the stop, missed the search, and was on later. And the reasoning was because as he took the driver, the defendant, out of the vehicle, that he struggled and his elbow hit the button to turn off the body cam. We didn't get to see that. We were told that. And the jury is not buying it. They were sent back to the jury room with bags of drugs, and they came back with a not guilty. This guy is going to be advertising his technique to everybody in jail. What do you bet he makes a motion to get his property returned? I don't know. What is it? Maybe he's his question about the money, where he's like, "What money? How much money did you collect?" And he's like, "None." Maybe that's what the jury thought. They're like, "Yeah, he's selling drugs, and he doesn't have any money on him. We don't buy that." Maybe they think the officer stole it, and so they set him free. I want to talk to the jury. Jury's like, "Nah, it's fine." It was 1 gram over, literally 1 gram. 1 gram is not a lot, right? I'm talking just sheer weight. Like if you were to look how much a gram was, it's a very small amount. But Josh, yes, thank you very much. Appreciate the tip. Josh is the one who tipped us off on this trial and led us down that road. There are audible notifications when cameras are turned on and off. 1 gram is the baggie. Yeah. Paperclip weighs 1 gram. So 15 of those, 15 paper clips, that's a fair amount, right? That's distribution quantity. According to the law, 14 grams, not distribution quantity. I wonder what it was that the jury just said not guilty. Maybe it's that they combined everything. The argument from the defendant that he stood up and he said, "So you took something in my pocket and combined it with something that wasn't in my pocket, something you alleged was in my pocket, combined with something that was not in my pocket to equal a certain amount, and then charge me for the other two that were not on me." Maybe that's what resonated. I did not see his pretrial. I know there's some stuff out there on pretrial. But this prosecutor, I'm going to have to go back and watch it on my own channel because now we can't do it any other way. I failed to record it. I should have. But 14 grams, a nice way to spend an afternoon. Yeah, does he get it back now? How does that work? It's just me. I don't know. We need to rewatch. We have to rewatch it with me in the corner, unfortunately, with my audio and everything. Man. It's going to get really confusing with all that. I think possibly. Oh, Judge Cedric's not back. I thought he was back. He's not. You can replay the stream to see the prosecutor's reaction. I'm going to replay it on my stream just so I can see. Oh, that's the wrong one. Man, they took that down so fast. And it's not playing nicely with me. Sorry, guys. Let's do it on the big screen. I'm going to rewind just a tiny bit. Okay, now we're going to play. This is going to be confusing, but this is me from before. Does that make sense? Let's get the music and everything. So we're going back to the future. This is like me, I'm now. But if I were to turn this off, then I become the old me. Here's a new me, old me, new me, old me, like that. Is that confusing enough? It took less than an hour for the jury to deliberate. Only 2 witnesses were heard. Pro se defendant did his best, but they were able to reach a verdict.
My understanding that the jurors have reached the verdict, is that correct? News report first.
Watch the prosecutor, guys.
Mr. Is it Pinnell?
Watch
Go hand the verdict form.
Prosecutor's right there on the bar, about to pump his fist in the air in victory. And he's going to review it here. Wow, we haven't had a verdict music in a while.
All right. Mr. Beecham, you'll rise. Madam Clerk, if you'll publish the verdict.
In the Circuit Court, 14th Judicial Circuit, State of Florida, in Throwback County. State of Florida versus Josiah Marquise Beecham. Case number 23 CF 4175. We, the jury, find as to the defendant, Josiah Marquise Beecham, as follows. Count 1, the defendant is not guilty. Count 2, the defendant is not guilty. Would say we all dated the 7th day of June 2024. Foreperson, Nicholas Pinnell.
Does anyone wish to have the jury polled?
He beat it.
All right.
He beat. Okay, so that was it. That was it. That's as loud as I can make it. It's loud in my ears for some reason. I've got to fix. When I reset this machine, when I updated it this morning, it messed up some settings inside. I've got to change the audio because it's deafening me. Like my ears are going to be ringing after this live stream. Wow, that was funny. Twubble, almost a year on the books. I was lurking before that. Soon, next month, we'll have you at Orange Courthouse. What a case. What a case. A one-day pro se gets the big win. I wonder if we could do a quick records check and see if there's anything else. I assume if there's nothing else holding him, he's out. He's free now. Goes back to jail, gets his clothes that he was arrested in, minus whatever was in his pockets, and gets to go on, call his girlfriend, say, hey, come get me in the car. Make some room, move the junk, come get me. As EDB says, if evidence can be interpreted 2 ways, it goes most favorable to the defendant. No body cam. Interpretation of the cop shut it off is favorable to the defendant. Yeah, and we know that he was he alleged he was a Moor, a type of pro se that believes that he's exempt. He's a descendant of the Mongolian Aboriginal people that made a treaty with the U.S. in the 1700s or something. It's a convoluted story. But he didn't really argue that in court. That is just nuts. Why was he wearing stripes? Because he's in custody. He said, part of my experience or my appearance, I haven't been able to afford bond. That's how he started his open. He wants to spin this makes the hot mic in the middle during jury deliberation even funnier. Or during the break, I should say, even funnier, because all the young attorneys and the court clerks, they're yucking it up. Ha ha, look at this. This is even better for me. How will I do? So how was it? How am I doing? And now he has to go back to that same group. They're going to be like, you lost? You lost to a guy in the jailbird outfit with 15 grams of Coke on the table? And you lost? Oh my goodness. And the defendant is going to be the king of the neighborhood. I'd ask to keep the outfit. He's like, this is my lucky jail uniform. I'll pay whatever. I'll pay the $10 to replace it. Man, I would so want to interview with the prosecutor right now. Who was it? Do we know the prosecutor? I would call him up. I'd be happy to. What's his name? Anybody know? Oh, he got this case because he's brand new. All the experienced attorneys they're dealing with some. I mean, this was a felony. This is a felony. It's not a little traffic infraction, but the experienced attorneys are doing, big, more important cases. This was the very bottom and being assigned a case solo on his own, no training wheels now, and he's expected to get there in court and come back with a win. And he's got his little paper out, and he's ready to mark the victory box for his turning in his how did I do self-assessment report to his boss, and now he has to go back and he's got a big old L on the front. Loss. He figured it would be a cakewalk. Yeah, he said at the beginning, and that was the arrogance. He says, "This is a simple case. It's easy. It's no brainer. Just 2 witnesses. Don't need anything else. It's practically, it proves itself." Famous last words. As a kid, I heard that the sage advice that to make your words soft and sweet, so that when the time comes for you to eat them, they will taste good and be easy to chew. And his brags at the beginning of trial and during the break are not easy to chew. Did I hear Runkle's Coke story? They were to show the evidence in court and accidentally cut the baggie of Coke, so it leaked all over. There's like dust in the air. The fans blowing it around. Everybody's getting high. Oh, man. The reaction to the chair spin was unprofessional. Oh, he's mad, but he's embarrassed. He's embarrassed more than he's mad. He beat the snarky cop. He beat the arrogant prosecutor. I will say the judge was fair. Curt, but fair. His instructions to the jury were very matter-of-fact, law-wise. He showed, at least to me, no preference as to what was done. I did notice, you might have missed it, as the jury went out to deliberate, the defendant made a motion for judgment of acquittal at that time, and the judge summarily denied it. But Curt was the judge? No, not Curt the person, like Curt as in short, to the point. This case made my day. Happy Friday, Dreama. Posted a clip in Discord of the lawyer throwing a fit. Oh, man. I love the chair spin. And the judge, when he read it, just put his hands together. He's like, well, you win some, you lose some. I think the judge thought this was open and shut. I mean, I didn't have the benefit of being able to see the jury and how they were receiving things. But, oh, man. That is just wild. Wild. Hey, you know who was in court this morning? And we did not follow live, but we can go back and watch the proceedings if you'd like. We haven't been there in a while, as a matter of fact. That was our good friend, Judge Wolf, the Heavenly Wood judge. You know who I'm talking about, right? Let's take a quick peek and see what he was up to this morning. This is this morning stream. It's done right now. Let's see what he had going on.
We'll start with the call of the docket. Call the first case, please.
Packard. Looks like a full courtroom. This is the Heavenly Wood courtroom. Love this courtroom. Underneath me is just, look at all that wood. That is beautiful. Like, craftsmen made this court. This was not something you bought at IKEA and put together. Yeah, if Sarah Boone saw that last trial we just watched, she'd be like, hey, maybe I can do this. No. Samantha, doing the homework, says Florida versus Josiah 2 counts drug possession, including trafficking of said drugs, found not
Good
guilty
morning.
on all charges. Good morning, Judge Wolf. Can we mic?
She looks like she's scared. Are you afraid of me? I wish people were afraid of me that are sitting in this courtroom, but unfortunately, I don't think they are. So you don't have any reason to be afraid of anything. We're going to take good care of you, okay? All right. All those who are going to testify in this case, raise your right hand. Let's place you under oath.
Okay. Testing 1, 2. Test 1, 2. Trying to fix my audio. It's just not right yet. Oh, you know what? These are family cases. I think they're doing adoptions. I think they're doing adoptions. These are so cool. Oh my goodness. Seeing families who have, become a family together, but become a family on paper. That's really cool. We don't have any mic here. We might skip ahead through this because we're not able to hear what's going on.
The microphone on the podium.
Oh.
I don't think it is.
The judge heard me.
I don't think it was known.
Wasn't on. So.
And you understand that you would have that obligation to pay child support, and you still would like for this adoption to occur. Can you state your name for the court, please?
Jacob Fox.
Okay. And Mr. Fox, this is a long day to get here, is that correct?
That's correct.
And you would like to be able to adopt, is that correct, your stepdaughter? And you understand that in the event that the two of you got divorced, that you may have a custody battle and that you may have an obligation to pay child support?
Yes.
And you understand that you have an obligation to support her for the rest of her life?
Yes.
Okay, and you're okay with that?
I am.
All right, and you understand that she would have a right to inherit from you in the event of death?
Yes.
And you still would like the court to grant this adoption? Your Honor, the natural father signed a consent on this and agreed to this adoption. The parties have been in custody matters in Cheatham County, and this was kind of a result of this.
All right, Mr. Fox, the main thing I have to ask you is that you understand, as Ms. Snow says, this is a permanent change in your status. Right now, you're just a stepfather, and that's a difficult job to be. But if we change it, it's going to become even more difficult because you're going to be her father the same as if she was your biological child. That means that she's got to do everything you ask her to do about taking care of her room, cleaning up her room and keeping it all straight and making good grades in school. And it also means that when she turns 16, you have to buy her a car and of her choice. At least that's the way I thought it went when I had my children at that age. So in any event, you understand the difference in being a stepfather and now that you're going to be the biological father. And you understand you can't bring her back to me when she brings some guy home that you don't approve of and you don't want her to date this guy and she's sneaking around and seeing him anyway. You can't bring her back to me. So do you understand all that?
I do.
Shauna, you are going to have your name changed. Do you understand that? And I make this offer to every person that comes before me with a name change. I can change your name to whatever you want it to. I can change it to Taylor Swift Fox if that's what you want, and that might get you some free tickets to some concerts. I don't know. Would you like to have your name changed to something like different than what your parents want, or do you want to just go with what they want? All right. Well, I think it's a wonderful compliment to you, Mr. Fox, that your wife and your now daughter both think enough of you and the relationship that you've formed to want you to become a permanent fixture in their life and to be the same as if you were her biological father. So I'm happy to grant your adoption, and as I often say, congratulations, it's a girl. So.
That is awesome.
Your Honor, they would, if the court would indulge us, they would like to have some pictures.
Sure.
And they have family members here as well.
Have them come on up.
That is awesome. And they get pictures. People are crying.
Everybody, let's have them come on up here.
Just come on up. Ascend the heavenly wood platform.
Donna, we're going to give you the big chair so you can see how impressive it is. You have a seat right here, okay?
She's like, wow.
Yeah.
You have a whole command center up here.
I wish. See, these lawyers need to take notice of that. Y'all come on over here. You got room?
Yes, sir. That is awesome.
If you were taller, it would help. Is that what you're saying?
I love, yeah, now I'm craned too. I love that the judge not just takes care of business, but makes it just such a memorable experience. Makes it such a memorable experience for her and for the family, and pauses court to take pictures. That's just awesome. Love Judge Wolf. And from that on to a felony, right? Big shift.
What?
See what's coming up next. Any other
Just
family?
let us know when they're here, Ms. Smith.
She couldn't come today. She was going to camp, so it's been moved.
So do you have another one?
Yes,
Which one is that?
I have Marva.
What we have here is a failure to communicate, because
That never happens to me. I can't, this is a first. Marbutt, Elijah Marbutt. Marbut. Okay, I'm sorry. No. That hasn't been.
we'll come back to it as soon as we get the file.
Okay, thank you.
The court paperwork isn't in order, so the judge doesn't have it before him. They'll pull the file. Not a problem.
Is a motion to set?
There's no opposition to it.
I'm sorry?
There's no opposition to it.
All right.
Half a day, maybe. It's property issues.
Ooh, property issues. We love the property issue ones in this trial, in this court. I wish we got the conclusion for the last
That's
one.
okay.
What day? And what judge is that? Me? Aren't I supposed to be in Stewart County? Am I not supposed to be in Stewart County on that day? I guess I did. All right, November 1st.
Thank you, Judge.
Thank you.
Good morning.
This is a post-divorce matter. We filed a petition for contempt, and
Is this Mr. Martin?
are you Mr. Martin? Yes, Judge. So we had filed a motion for default for Mr. Martin's failure to answer within the 30-day period. I talked to him about the motion for default. We served him with that, and even then, he has not cured the answer. So at this point, we're still asking for a default judgment and a final hearing
Default
or
judgment
damages.
of divorce for failure to respond. Judge is licking all the pages. Jen, you can finally comment. Welcome, Jen. Love the horse, by the way. Looks like a ribbon
Mr.
with
Martin, you were served with a copy of this complaint. That summons that was served on you stated as follows. You are summoned to defend a civil action filed against you in the Chancery Court of Dixon County, Tennessee. Your defense must be made within 30 days from the date of this summons is served upon you. You must file your defense with the clerk of the court and send a copy to the plaintiff's attorney at the address listed below. If you fail to defend this action by the above date, judgment by default can be rendered against you for the relief sought in the complaint. So we are here today because you have not filed an answer or otherwise contested the issues that are raised in the petition for contempt that was brought. So that you understand, it is alleged that on or about that you were ordered to pay monthly child support in the amount of $2,144 beginning April of 2023, and as of the filing of this petition, you had paid a total of $23,000. I think that April of 2023 was an incorrect. Well, that would be correct. This is filed in April of 24. It's alleged that you were $2,328 in arrears in the child support. It also alleges that you were ordered to pay monthly alimony of $2,000 for a period of 3 years, and that you had paid $0 towards the alimony, resulting in a $24,000 arrearage. You were ordered to pay monthly storage fees for her until she was able to secure an apartment. These are all things that were agreed to in a marital dissolution agreement. It wasn't a court hearing. This is what you two agreed to. To date, as of the filing of this petition, it's alleged that you had failed to make any payments and that there was an arrearage of $4,380 in storage fees. And that you were ordered to maintain health insurance coverage, and that you had failed to provide health insurance coverage, and that she was forced to enroll the children in TennCare, which means that those of us who pay taxes in the state of Tennessee are paying for your children's health coverage. Under the marital dissolution agreement, you were to be responsible for any unpaid medical bills for the children, and there's $2,073 in arrearage owing. You were to be responsible for any debt under both your names, and she's received a letter saying that there is $5,751.41 owing on an installment agreement with the state of California for back taxes. So what she's asking is that I grant a default judgment against you for all of those things. Do you understand that? All right, default judgment is granted. Do you want to set it for a hearing as to disposition?
Yes, Judge, and we're actually ready for the damages. We filed an affidavit specifying the damages along with the exhibits.
Well, it's not damages. It would be the amount that he's in contempt for.
Yes, Judge.
Well, then why would we need to have a hearing if you're asking for all of those things to be granted to you today? Why set a hearing if you're asking for a judgment against him for those amounts?
Yes, Judge, so we can just set a hearing for the final hearing?
Well, here's the thing. A default judgment is being entered against you because you haven't filed an answer and haven't contested any of these issues. Now, what happens in that is subject to the court determining there are things I can do. I can enter a judgment against you and give you a certain specific time to bring that current. And if you don't bring it current, you go to jail, or I can go ahead and put you in jail at the first, because you've been found to be in contempt. So the question, what I do, is what we would have to have a hearing for. Have you talked with a lawyer about this situation, Mr. Martin? Well, you may live here. You may live up here on a hill at the county jail, because civil contempt means I put you in jail for a period of up to 6 months, or until you purge yourself of contempt. So what that means is that if I find that you are willfully not complying with the court order, then I will be required to incarcerate you and then give you an opportunity to pay it, suspending that sentence. And if you don't pay it, then I would revoke that suspended sentence and put you in jail. That's typically the way it's happened. But where you live, in North Carolina? Where?
Hey, don't throw us under the bus.
You work in Arizona and live in Nevada, live in Las Vegas. Well, I'm going to suggest we need to go ahead and get this heard as quickly as possible, but obviously it needs to be, if you're planning on hiring a lawyer, I would suggest that you get one hired.
He agreed to this. This
I
was
know
their
the 18th
agreement,
of June is a
not a
full
court
day.
ruling. Did he just not read the paperwork and just signed everything?
Ms. McKinney, on the 25th of June, we still have the Cheatham Chancery cases. Yeah. What about July 17th?
Which will be pretty short.
What now?
Never mind, Judge.
I was wondering if you were going to say the Strickland case was going to be quick, which I was going to call you on that one.
So that judgment of default, or that's a black mark on his record, and now it goes to a hearing. It doesn't actually change anything. It doesn't get her any money.
August the 1st.
But the hearing, then the judge will now proceed with this established that he has defaulted.
I'm going to set it for August the 1st at 8:30 in the morning. Mr. Morton, I'm granting a default judgment, which means that the issues are being on a default, means that all we're going to be talking about is how we're going to deal with your failure to comply with the court order. That's not whether or not you go to jail or whether or not there's some other disposition will be decided on that day. I would suggest strongly that you make arrangements to try to cure this defect between now and that August 1st date, and if you don't, then that'll obviously be something the court will have to take into consideration. Show that it will be at 8:30 on the first day of August.
Thank you, Judge.
All right. Pardon? What do you want to ask?
Please go to the mic.
I'm going to suggest you agreed to this under the marital dissolution agreement, and so I'm being asked to enforce the marital dissolution agreement. I didn't order it, the judge didn't order it, except that the two of you agreed to it. So what I'm suggesting to you is that you consult an attorney about your options. I can't give you legal advice, but right now there's a default judgment entered against you. There are methods by which you can try to set aside a default, but you have to consult an attorney or do your own research to try to find that out. We will then have a hearing on August the 1st at 8:30, and you have an opportunity to try to get some legal advice about this matter before then. All right, thank you.
Wow. You have an opportunity to either pay up. I mean, you've got two options. Get current, pay all the money, get a good lawyer, and start praying. That's it. Those are your options. Either way, you got to be back in court. Judge Wolf, what's up next? Do you have something? Ooh, another adoption. Went from light and happy to serious, and now back to light and happy.
All right, if we've got family members who are here for this adoption, if you want to come up and be a part of it, come on up and surround them. They probably need the moral support, if nothing else. So.
Big family.
All right. All those who are going to testify in this case, raise your right hand and be placed under oath. Yes. So all of you are going to testify, right?
Just covering bases.
We may have to cut that down just a little bit, so. Ms. Smith?
Emily, would you state your name?
My name is Emily Sis.
And Ms. Sis, are you presently the foster mother? How long have you been?
A year and 3 months.
A year and 3 months. Bonded with it.
Very much, yeah.
And you really want to adopt?
Yes.
And you understand.
Okay, we're gonna have to bail. We just can't hear. The mics are so bad. Please see mod chat. Let me take a quick peek.
My experience forever. And you wanted that to happen.
Yes.
And you're excited today.
I'm very excited.
And would you state your name, please?
Daniel Sisk.
And
100%.
yeah, I thought so.
Okay.
And is Elijah presently?
I hate to cut them off in the middle of their happy day.
Really wasn't necessary for you to bring me a gift, but I see that you have, so. Mr. and Ms. Sisk, I want to make sure that you both understand. Do you have any other children?
We have a foster son.
All right. So have you ever raised a teenage boy?
I've helped a little bit, yeah.
He's a handsome young man right now. I think he actually is starting to favor his father a little bit. So, in any event,
That's good.
they're really cute when they're this age and they talk to you and everything. But when they get to be teenage boys, and I've seen one that's kind of over your shoulder that's almost there, when they get to be teenagers, sometimes it's a little bit more difficult to interact with them and get them off of their games that they're playing or whatever. But you understand that this is going to be a permanent relationship that we're creating today, and it will be the same as if he was your biological son.
Yes, sir.
And that means that when he gets to be that teenage boy and doesn't take a shower often enough or does some other things that teenage boys are known to do, then you can't come back to me and say, this is a terrible mistake, I want to undo it. You understand that? And all of these necessary consents and termination of rights have been supplied to the court, and I'm happy to grant your adoption. So.
Thank you.
Thank you.
There's no interaction with the child because the child probably doesn't comprehend what's going on right now. 18 months old or so.
You may.
They want a picture as well.
Where do you want to take? Do you want everybody involved in it, or you want?
Sure.
You want everybody?
I want everyone.
Oh.
Yeah.
Then they just need to line up probably here. So I'll come down there. How about that?
Don't trip over the robes. Okay, let me disappear so you guys can watch. See the family photo.
No, go ahead. I'm good. I just.
Judge straightens his hair, takes off his glasses.
Elijah. And you need to get in there. No, I'm not going.
I'm the attorney. Get in there. Family members get in. Attorney's now taking the pictures. This will count as billable hours.
I don't think I can. Yeah, I got you. Everybody look up and say Fuzzy Pickles.
You said say Fuzzy Pickles. Let me just say the picture.
I don't listen well.
The pictures could turn out terrible. Our view was the best. Our view was the best. It wasn't the sharpest focus, but the podium was in everybody's shot. When my wife and I got married, our photographer used that same say Fuzzy Pickles. It wasn't
Very
just
good.
cute.
Thank you. Don't move yet. Send me that.
It's a feel-good Friday. We've had everything today. We've had a pro se defendant beat the charges, win a jury trial.
souvenir. They're all-
Oh, nice.
I'll give it to Elijah too.
What's he giving out? Does he give out like special pens? Or did he just give away his gavel? I don't know. He gave it to the foster child.
Thank you, Judge.
This poor judge is overworked and underpaid. My family says whiskey for pictures. Better saying than drinking. Too many, is it toy gavels? Too many whiskeys before pictures ends up in a non-photogenic situation.
Morning, Judge.
So
a motion to quash and a motion for a protective order.
Ooh.
Yes, sir.
Happy sad.
My name's Hannah Davis. I represent the Department of Children's Services. We're here in part on our motion to quash. We were served with subpoenas to provide Ms. Smith our records on Delilah, I believe it's Quinones, and Nixia Quinones. This case includes allegations of sexual abuse, which points us to TCA 371612.
There we go. There we go. And on that note, it went from happy to sad. Now we're crying again, but for different reasons. Fuzzy Pickles is an Earthbound reference to Super Nintendo Entertainment System video game. I did not know that. Did not know that. Yeah. Bye-bye. Bye-bye. Wow. We'll end on the high notes and just pretend we didn't hear the last little bit. Let's see. What do we have left to do? It's Friday. It's Friday. We've had verdict music. We've had some crazy stuff. I think it might be time. See, I don't see Judge Cedric. Let me do one more pass. Oh, Simpson's back on the bench. Hold on. We can't go yet. Can't go yet. Simpson's back.
Right. Yeah. Okay. If it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes.
Okay. And understanding that, you still wish to plead to this charge?
Yes.
All right. Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2311203. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be July 10th, 2024, 9 a.m.
Thank you.
Thank you. Bond will continue. Thank you. Sir, on your way out, stop down and just say something to the probation department so we can get that started. Okay?
Yes.
Thank you.
Thank you, Your Honor. Thank you, sir.
If we've got a pause.
Oh, okay. Okay, so she signed in the Zoom. Right. I knew she did have to leave.
If we've got a
Court
pause.
does call the case People versus Robert Jones.
We are anticipating covering the Wade Wilson trial that starts on Monday, just so you guys know. We're in
Carolyn
talks with the
Fox
court
with the Crown
right
on
now
behalf of
about
Robert
access. Oh, look at this guy. Thanks for dressing appropriately for court. Straight
Oh,
from
Jones.
CrossFit.
Okay. What are we doing?
We are
Shorts
Doing
and
the
muscle
jury
shirt.
selection.
We are continuing to jury selection.
Matter will continue to jury selection. June 10th, 2024, 8:30. Sir, next time that you appear in my court, make sure you're properly attired. Don't like shorts.
I apologize, sir.
Thank you.
Your Honor,
Judge.
did you want the jury instructions
What?
list? The instructions.
They need to be filed with the clerk's office in West Michael.
It's No Pants
Thank
Friday.
you. Thank you,
Your Honor.
sir.
If
Court
I
calls
may
case People
respectfully
versus
object.
Unique Haywood.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Haywood.
All right. Yes.
Yes, Your Honor. We're asking for adjournment of the final settlement conference, Your Honor.
Adjourn jury final settlement conference to August 9th, 2024 at 9 a.m. Jury selection will be adjourned to August 12th, 2024 at 8:30. Both of those proceedings are in person, and that way we can make sure everything's prepared to go forth.
Thank you, Judge.
Thank you, Bond. Indeed. Thank you. Court calls the case, People versus Misty Perkins.
Misty Perkins.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Perkins. State your
Here's
name.
Misty.
We have come to some sort of resolution.
What does that
Ms. Perkins, I have explained Ms. Perkins' constitutional right to a jury trial. She's going to waive her right to a jury trial and set this for bench. And Ms. Broso and I are going to have continued conversations.
All right, very good. Ma'am, is that correct?
Yes, sir.
You understand that you have an absolute and constitutional right to have the matter tried before a jury.
Yes, sir.
You understand that by waiving that right, it'd be tried before this court without a jury present.
Yes, sir.
People also waive their right.
Yes, sir.
Based upon the statement of counsel, the defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter would be set for.
June 24th at 9 a.m.
Will that be enough time for you guys?
Yes, Your Honor.
I drive from Newaygo.
Pardon?
I drive all the way here from Newaygo, so it's like hard for me to get here.
Okay, but
If I gotta come, I gotta come. I'd rather come than go to jail, but.
what a concept. Right. Why don't I set it that date? I know people are trying to work some things, so let's try that date, okay?
Okay, thank you.
June 24th, 2024, 9 a.m.
Okay.
All right. Thank you, ma'am.
Thank you.
All right, drive safely, please.
Thank you.
I would almost ask if you have a license, but I've heard enough. Okay, no, never mind. Court calls the case, People versus Delmore Brown.
Good afternoon, Your Honor. Nicole Hughes on behalf of the people.
All right, good afternoon. Ms. Barosa, you have a great weekend.
So the client's here, attorney's on
Afternoon,
Zoom.
still afternoon. Assistant Public Defender Lauren Perny on behalf of Mr. Brown. From take your name for the record.
Delmore Brown. All right. The record should reflect we had a significant bench conference regarding this case, other pending matters that are kind of going along with it. And in that case, I think, given all of that, what the court's going to do is the court's going to adjourn this out to my next jury selection day. Miss, you had something you wanted to say?
Yes, Your Honor. I just want to put on the record, Mr. Brown is ready and able to try this case. He would like to try it as quickly as possible. Would object to it being placed on that date. Again, we'd be ready to go.
All right. And the court is doing it on its own motion. I note the objection of counsel that you expressed that objection strenuously to the court in chambers, as well as to the prosecutor. I think it's in the best interest of this case and of justice to adjourn this matter out. So I'm going to adjourn this to August 9th, 2024 at 9 for jury final settlement conference. And then jury selection would be August 12th, 2024, 8:30. Those will be in person. Bond with its conditions will continue.
Thank you.
Sir, I'm going to tell you what, check yourself. Check yourself as to how you leave this courtroom. I was watching you. You may leave now.
That one might be something to watch. Somebody put a little asterisk on, what was it, August 12th, court date? Jury trial? Will it be in his court?
This one's waving.
Yes, sir.
Court does call the case of the People versus Brian Gonzalez Hernandez.
I apologize. Do I need to wait for the interpreter? I'm sorry.
Yes. We have an interpreter present. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment, and to translate from English into Spanish, and from Spanish into English in the manner now before the court so help you God?
Ayden.
State your name.
Kamal Hanawi.
Thank you. Well, all right. Go ahead.
Nicole Hughes on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Gonzalez Hernandez.
My understanding is he's waiving his right to a trial by jury.
That is correct, Your Honor, and we are asking for this to be set for a bench trial.
Sir, you understand that you have an absolute and constitutional right to have this matter tried before a jury?
Yes.
And you understand that by waiving that right, it will be tried before this court without a jury present?
Yes.
The people also waive their right?
Yes. Sorry. Yes, Your Honor.
Based upon the statement of counsel and defendant, the court will consent to have the matter tried before it without a jury. Non-jury trial will be set for June 24th, 2024, 9 a.m. Bond will continue. Thank you.
Thank you. Thank you, Your Honor. Would you like Mr. Gonzalez Hernandez to sign the waiver? Thank you.
A bench trial is where the judge is also the jury. A jury trial is where the jury just determines guilt, and then, and depending on the sentence and the state, the sentence. So, a bench trial would be skip the jury.
Thank you, Your Honor.
The judge hears all the evidence and he rules on it.
Thank you, Ms. Hughes, for stepping in. We ran a little bit long for Mr. Rosa.
problem. Thank you so much.
All right. Take care. Have a great weekend. That's it for us. 14A stands adjourned.
14A stands adjourned. He's done. He gone. He gone. It's the weekend. Now we can start the weekend because Judge Simpson started his weekend. Oh, man. 1 hour till my interview for a possible promotion in our department, and here I am in the hammock with y'all. Kim, you're going to knock it out of the park. Good luck to you. Good luck. You're going to do great. Someone's playing ping pong. Yes, my kids are playing ping pong on the kitchen table in the room on the opposite hall. Can you hear that? Should probably close the door. I'll probably join them, play some ping pong as well. It's been a great week. It has been amazing. We had a wonderful podcast yesterday. If you missed that, please go back and watch it. Share it with a friend. We'd love that as well. We've had a little bit of everything, a little bit of crazy, maybe a lot of crazy this week. Oh, man. I like it. From the bottom of my heart, thank you to our amazing mods who make this all possible. Thank you, thank you. Just back to the subset win. Yes, he did, Martha. You've got to go back and watch it. Mods, thank you all. Thank you for all you do. I know each of you have specialties in different areas, and some of you are a master of everything. Thank you. I appreciate that. To everyone else, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again on Monday. We'll have Karen Reed, I believe, Monday. We also might be picking up, possibly on the Top Mark Media channel, the tattoo face guy, Wade Wilson. That's where we're looking. We might do it because Karen Reed's going to go on for I don't know, another eternity, and this trial is starting. So we'll see what we have to do. You guys have a good one. Have a great weekend. Thank you all. Be nice to each other. We'll see you. Bye bye.
Is that correct?
There's a lawsuit.
I'd agree that everything you just said is one of the most horrible things I've ever heard.
Alex Stollett.